May I plead your lordship?
Just 1 second. Let me just quickly settle down. Yes, please.
Lordship, with the consent of the petitioner, I'd like to mention item number 50. Lordship,
50.
50. I need 2 weeks time to file our objection in IA, Lordship.
Have you informed the other
Yes, yes,
side?
Lordship, I have informed all the parties.
This is an IA.
Yes, Lordship.
There is a delay.
No, Lordship,
Leave.
it's review for IA, Lordship, for actually for leave.
All right. You are MS?
MSR Kakoti. I am for the respondent.
MSR Kakoti, Learned Counsel appearing for the respondent number 1 with consent from the Learned
Petitioner.
Counsel appearing for the applicant seeks
2 weeks time.
2 weeks time to file
Objection.
objection in the matter. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
My lord, there's an item 49. I'm for the petitioner. We would like to withdraw the case, ma'am.
You want to withdraw it?
Yes, ma'am.
Other side is there.
The side is agriculture department.
Anyone from the agriculture department? GA Assam is there. Mr. Goswami, you are there. As heard Mr. I. Borthakur, Learned Counsel appearing for the petitioner. Also heard Mr. N. Goswami, Learned Government Counsel appearing for the state. Mr. Borthakur, Learned Counsel for the writ petitioner, submits that he has received instructions not to press the instant writ petition and accordingly makes an endorsement to the same effect. In view of the aforesaid endorsement, the writ petition stands dismissed on being withdrawn. Disposed of.
May I please, as a lordship? May
Yes.
I please, as a lordship? My lord, I beg to mention daily item list, my lord, item number 6, my lord.
6.
Item 6, my lord.
Yes, what do you want?
My lord, a short accommodation because my lord,
For
the
filing reply.
my lord reply we have filed, my lord. But the my lord, the council conducting a Z Hamad, his mother has expired, my lord.
As
So,
prayed for by Mr. A.R. Bhuya,
my lord,
Learned Counsel appearing for the petitioner, relist after,
2 weeks, my lord.
give a date after 4 weeks.
Yes, yes.
Relist on such and such date.
May
Yes.
I please, your lordship? Item number 2.
My lord, there is an interim order that
Interim, if any, shall continue till the next date of listing.
of
May I
a-
please, your
Please.
lordship? Item number 2. The petitioner has decided to withdraw the writ petition.
Item number 2. You are
R. Raska, your lordship.
heard Mr. R. Rajkwal, Learned Counsel for the petitioner. Also heard Mr. N. Goswami, Learned Counsel for the state, and Mr. A. Bhattacharjee. G, right? Bhattacharjee or Bhattacharya? Huh? Bhattacharya, Learned Standing Counsel Revenue. Mr. Rajkwal, Learned so and so, he agonisna corridor and disposed of.
Please, your lordship. I beg to mention item number 21, your lordship. I am for respondent number 7 and 8, your lordship.
21.
Yes, your lordship.
You are for someone had filed an AO here.
Yes, we have filed, your lordship.
You have filed your AO.
Yes, your lordship.
What do you want today?
Lordship, I am seeking adjournment, your lordship. The consent of the other side has.
Why
already
you have
taken-
filed your return? Why you want an adjournment?
Lordship, today especially there is some difficulty, your lordship. The senior counsel, Mr. P.J. Sekhe, is out of station, your lordship.
All right. Item 22.
21.
21. As prayed for by Mr.
K.J. Sekhe, your lordship.
So and so, Learned Counsel appearing for the respondent number 7 and 8.
Yes, your lordship.
With consent from the other side, relist after
2 weeks, your
2
lordship.
weeks on a date to be fixed by the registry.
May please, your lordship. Your lordship, I beg to mention item number 1.
1. Item 1 is going to be called out, Mr. Counsel. Just wait. Why to mention item 1?
Obligation.
That's going to be the first. Yes. Yes, come. Why you have not taken steps?
Your lordship, some technical issues were arise. Because of that, we couldn't complete the service.
No. What technical difficulties? Are you going to take steps or you're not going to take steps?
No, your lordship will take the steps. Kindly grant some days.
So say that. How much time?
3 to 4 days.
Your name.
S. Bora,
Mr. S. Bora, Learned Counsel appearing for the
petitioner.
petitioner, assures that the requisite steps as directed earlier by this court shall be taken positively within 3 days from today. In view of the aforesaid assurance, relist after 2 weeks on a date to be fixed by the registry.
Oblige, Your Honor.
May it please your Honor.
Yes, affidavit in opposition. Affidavit in opposition was supposed to be filed. Only R4's affidavit is here.
Yes, Lordship.
Yes,
Lordship,
revocation date.
Yes, Lordship. Lordship, a deed of irrevocable general power of attorney was registered by the senior sub-registrar of Tezpur, Lordship, under so and so, book number, serial number, and deed number, Your Honor, for the year of 2014 on 24th of February of 2014. Then, Your Honor, subsequently, what happened, Your Honor, after 2 years, on 2/6/2016, Your Honor, and another deed of revocation of irrecoverable general power of attorney at the back of the petitioner, Your Honor, the respondent number 5 to 12, Your Honor, they presented before the senior
Who is
sub-registrar.
appearing for 5 to 12?
Lordship, advocate for the respondent of 5 to 12 is absent today. As
Why?
Lordship,
You are for?
I'm on behalf of DK Medi, Lordship.
No, we are appearing for whom?
Respondent number 5 to 12, Lordship.
So where is your affidavit?
Lordship, actually, he just called me for seeking.
Why are you not opening your mouth, ma'am? Why are you waiting? You say I've been asking what about the affidavit? Why are you waiting for the court to seek clarification? You must first say if you have come to say something on behalf of some other counsel. Yes, what do you want to say?
Lordship, actually, what happened, he's out of station due to his senior's daughter's death, Lordship.
Sorry?
Due to the death of the daughter of his senior, SK Singh, Lordship, he had to go to Tezpur yesterday, Lordship, immediately. So he couldn't come.
Mention is being made on behalf of Mr.
DK Medi, Lordship.
DK Medi, learned counsel appearing for the respondent number 5 to 12. Due to humanity demands. Stop. The matter MS so and so has made the mention and also seeks accommodation on his behalf. Prayer is not opposed. When do you want?
Your Honor, after short date may be given, Your Honor.
List on next week at a date detail.
6th of last year.
Yes, why demarcation is not being done? Rejoinder was also supposed to be filed. Where is the petitioner?
My lord, we have filed the affidavit, my lord, also disposed of it, my lord. Now, my lord, government has constituted a commission, my lord, as per the, my lord, paragraph 1 of the 6th schedule.
Children, can you get hold of the petitioner? I'll keep it for some time. Get hold of the petitioner. This court is giving you liberty. If you get hold of him, just mention the court master. We'll call it up.
Lordship, I've taken under it.
Let's see if it can be disposed of.
My lord, it can be disposed of.
So that is why I'm saying just see if he's around.
At whom, my lord, that-
Just have a look. Give him a call. Eviction notice. Yes. Why counsels are not in court? All up pisat mati ko ito.
Lordship, here in this case, we had, the bank had already filed the affidavit. There is a high level committee where there is an allegation. Lordship,
No one is there. Wait for some time. We'll recall the matters.
Lordship.
Yes, Mr. Buragohai.
May it please the Lordship.
Some additional affidavit was required to be filed.
My lord, there has been some important development actually, my lord. The orders and the decisions that has been impugned in the current writ petition, my lord. My lord, the IOCL authorities subsequently during the pendency has already terminated the dealership concerned. Now, we challenge the decision of putting the petrol depot under a scheme called holiday scheme.
That is cancelled.
Now, that holiday scheme, by way of adopting that policy, and consequentially, my lord, they are to either give an opportunity to us to come into consensus and you resolve your dispute and you continue to run the petrol pump. However, we could not come into any consensus during the pendency. So ultimately, they terminated the the dealership.
That is now you probably have to.
Go for a fresh cause of action, my lord, and this kind of has become infectious, my lord.
So then you make that submission on that basis, I'll close it.
My lord, only one thing is that, my lord, my learned friend is here. I don't have a copy of the termination letter. So if you can just mention the order of the termination.
I have already provided the information.
No, today I'm not carrying, my lord. Of course, he has with one, my lord. It is my lord, this is the copy, my lord.
No, Porva. Ekman, Porva, Ekman.
Insofar as the scheme and the challenge to the scheme is concerned, my lord, the cause of action actually still subsists, my lord, because it is a consequential order. The termination is.
So what do you want to do?
May I submit, my lord? Can we have, my lord, some time, 1 or
So you you examine and you file an additional affidavit if need be.
Yes, my lord. We'll go into that aspect, my lord.
Yeah. This case, I will take.
Yes, Mr. Nayak.
No, that's fine. Neither the petitioner nor the respondent filed the cancellation.
That's what.
So never ultimately became infraction. So
Huh?
one last opportunity may be given to both the parties, not IOC.
Mr. P. Nayak, Learned Counsel, appearing for respondent number 6, submits that though the dealership has been subject dealership,
Yes, my lord.
that though the subject dealership has been terminated, yet neither the petitioner nor the respondent IO.
No, they have issued the cancellation order.
No, but you said IOCL has also not brought in on record. Who is appearing for IOCL?
Yes,
IOCL has filed any affidavit bringing the said document on record. Mr. A.C. Buragohai, Learned Counsel for the petitioner, submits that he may be given some accommodation. He may be given he may be given some. He may be accommodated to bring the aforesaid development on record
My lord.
and also examine as whether anything still survives
Yes, my lord.
for adjudication in the present
My
writ
lord.
petition. Prayer is allowed. Relist on
My lord, maybe after 3 weeks, my lord.
not 3 weeks. Yes, 2 weeks after the
2
delay
weeks, my lord.
on such and such
Yes.
days.
I'm highly obliged, my lord.
This you take it back.
Yes, my lord. I'll bring it on record.
But you bring whatever you want to bring, and if this becomes infractious, this
Then we'll
court will
file for a
because, it looks like now you have a fresh cause of
Cause
action.
of action, correct, my lord. I'm highly obliged, my lord.
Please, your lordship. Lordship may take it to lordship.
Why?
Lordship, Ayasudori is going to do
Huh?
Ayasudori is going to his asylum school, lordship. So
I Chaudhary is going where?
school, it's a children's school.
Next week, Lord.
Huh?
Next week.
Take it to lordship.
No.
Will we come?
Affidavits have been filed.
One affidavit file, but some more instructions is required, Lord.
Some more instructions. required.
Lord.
Heard, Mister, your name.
Adel Sutia.
Your name.
Adel Sutia.
So and so, Learned Counsel for the petitioner, also heard Mr. N. Goswami, Learned Government Counsel, appearing for the state. Mr. Goswami says, though an affidavit in opposition has been filed on behalf of the state respondent, however, he seeks a short accommodation to bring few additional facts on record. Prayer is allowed. Relist on next week.
2 weeks, Lord. 2 weeks, Lord.
No, what 2 weeks?
10 days, Lord.
10 days of on such and such date to enable the state respondent to file the additional affidavit if they so desire. failing which the matter shall be proceeded in accordance with law
Oblige.
on the next date.
That being item number 7.
May I please, Your Lordship?
Yes,
My lord, I'm extremely sorry, I could not attend.
that's all right. This relates to some payment of deposited bank amount.
Bank amount, my lord, but
Hmm.
there was a fraud, my lord, committed by the bank manager, my lord. Huge scandal.
PNB.
He accepted mallet when matter was found mallet.
He-
Probably he-
Yo, Mati দিছে এইটো তেওঁ নাই। ক'ত আছে তেখেত?
BN Gogoi, he is on behalf of the bank, my lord.
Yes, he was there when you were not here.
Then
Why are you
I'm-
calling it out of turn when the council is not here? So, wait. Your counterpart, come. You're coming to do.
We had already filed our counter affidavit, Your Lordship. And that affidavit already shows that there is a high-powered committee have been constituted for the allegations of the amount. And thereafter, Your Lordship, in our
But
affidavit,
what is the high powered committee doing?
they had dismissed that person who have been,
They have?
the committee has dismissed the person who have been involving in this case as a bank.
Where have you said all that? First of all, what is the allegation, Mr. Counsel?
May I submit, my lord? The case is that, my lord, perhaps it will be the heaviest and most financial scandal, bank scandal, my lord, in the state, my lord. My lord, near about 2 crores fraud, my lord, has been committed by the bank manager, my lord. He was put suspended. That is another issue, my lord. After happening this, my lord, then there was a 3-man committee, my lord, comprising of high officials, my lord, of the bank. And 3-man committee, my lord, took personal hearing of each and every customer of the bank. Then, my lord, the 3-man committee found the case, my lord, fit, and their claim found to be fit, and they prepared summary claim, my lord. Kindly see the summary claim, page 19, my lord. So summary of claim, my lord, page 19. Then 20 relevant portion, my lord. It was also voluminous, my lord, but I have just annexed here relevant portion, 2 pages.
Page 19 is
Headed by the line, my lord, particulars for seeking authorization for payment of amounts involved in branch office, Zoleshwar, my lord. Now, serial number 4, my lord, 68. This is the, he is the petitioner, my lord. Abdul Salam.
yes.
Then amount, my lord, 4,87,000, my lord.
This is not correct.
This is correct. Now, my lord, they have a 3-man committee has found my amount as such, and they have prepared this, my lord, 3-man, my lord, summary of claim, and they have
What is your prayer in the writ petition?
prayer, my lord, to pay this amount, my lord. Direction to the bank authority to pay this amount. Now, my lord, amount more than 2 lakhs, my lord, they have sent to the head office, my lord, Calcutta.
Now, this is admitted that this amount is due to the petitioner?
No, Lordship.
No. Yes, where you said the 3-man committee has said it is admittedly due. Where is that finding?
And my lord, they have lost FIR also, page 12, my lord.
So where is the report of the committee?
Report of the committee, my lord. Kindly see page 18, my lord. This is not report, my lord, but the RBI, my lord, took up this case, my lord.
Now, this is about a fraud.
Yes, this is about the fraud. Thereafter, they, my lord, the 3-man committee was formed, my lord.
Yes.
And
where
then
is the report?
this is the record, my lord.
Huh?
This is the record, only record, particulars for
Where-
seeking
where? Page?
authorization. Page, my lord, 20.
That is the report.
Not report, my lord, but 3-man committee
Mr.
prepared.
Gopal, you said your affidavit has some reference.
Yes,
to
Your Lordship,
committee
please annexer 2.
Page.
It is in the annexer 2, Your Lordship. I take to apologize, Your Lordship. Annexer 1 is the, if Lordship permit me, annexer 1 is the receipt copy where he has amount says about a 4,88,000
1 second. Page.
I have not marked, your lordship. Annexure 1 is if lordship take the apology. Annexure 1.
Page number is not given, my lord.
Annexure A. Annexure A is a receipt.
Yes, lordship.
What is this receipt?
They received then annexure 2, your lordship. Serial number 68. What is mentioned? May I read, your lordship?
Huh?
Cash receipt seal counterfoil dated 10/9/2012 and 11/9/2012 appears to be different than the cash receipt. Seal used by the branch on those days, moreover, deposit amounts very high in comparison with earlier
I'm
transactions.
sorry, counsels, you're not being clear enough. I'm not following anything right now. What is the fraud?
The amount which have been deposited by him is not tally or not been recorded in anywhere in the bank account.
Now, where have this been said in the affidavit?
Yes, lordship, it is there.
My lord, page number is not been given. This is the problem, my lord.
I cannot understand when both counsels will speak. Let Mr. Gogoi present his affidavit first.
Lordship.
Yes, where in your affidavit have you taken this 10? Please show me.
Last page, your lordship. Last piece of my.
What do you mean by last page? Why you don't have the page marks? Why your affidavit doesn't contain any internal page mark? What is this way of assisting the court? This is the basic minimum assistance this court expects from the bar. Is this the way you assist the court?
I beg to apologize, lordship. This has been done earlier before. I may be.
If you don't have the pagination in your affidavit, at least you could have come before 10:30, checked the file and got the running pages noted. Yes, last page of your affidavit.
Yes, in the bank statement is written there.
See, unnecessarily you are wasting judicial time.
This is the statement.
Yes, what is wrong in this finding?
Findings wrong, my lord, because my
Why?
lord, this is not individual case. It is as a whole case, my
How will this court go into all this?
my lord, kindly
This
see
is the
page.
226 court.
Now, my lord, kindly
The
see.
stand here is very clear. Further, this deponent begs to state that the application filed by the petitioner dated 5/10/12 on the issue of the subject matter in regard to the anomalies in his saving account. It has been found that balance amount in manual passbook as on date 11/9/12 for an amount of rupees 2225 is on record, but not for an amount of rupees 489225, which was claimed. The balance is computerized passbook as on 4/7/12 for an amount of rupees 1194 is on record. Hence, the difference between the balance in manual passbook and the computerized passbook account is on rupees 1031, but not the amount of rupees 488031, which was claimed.
Yes, my lord, that is the anomaly. That is the fraud committed by the bank manager. They have, my lord, mentioned stated in the FIR. FIR is clear, my lord. That is the scandal. That is the fraud committed by the bank manager. Kindly see page 10, my lord. Serially, my lord. Sorry.
Your reply, what have you said against this paragraph?
I have said, my lord. My lord,
Paragraph,
kindly see page 10, my lord. May I read as recommended by the committee.
Your reply affidavit.
No, it is also on record, my lord. Therefore.
Please come to your reply affidavit, Mr. Counsel.
Yes, my lord.
Where have you replied to paragraph 6?
Paragraph 6, my lord. Page 3, my lord. Page 3, my lord. May I read, my lord?
Yes.
That with regard to the statement made in paragraph 6, the answering deponent oblique writ petitioner, while admitting partly, denies the rest and begs to state that the worksheet of claim annexure 1 to the affidavit in opposition is doubtful, in as much as same is shown to have signed by 4 members committee, though admittedly it was a 3-man committee. My lord, that is signed by 4 members committee, but committee was of 3 men, my lord. Moreover, the so-called purported worksheet of claim is shown to have manufactured wherein no date is mentioned, which goes to show that the said homework is done on afterthought
You
basis.
have the original, Mr. Gogoi, do you have the original? The records you have,
No, I don't have.
get the records.
Let the records be called for.
And my lord,
Sir.
here,
Yes,
How otherwise, how will this court go into all this? If the record smacks of some doubt, then of
Yeah.
course,
Lords.
this court can think of something. If the records are clean, nothing, and this is
Yeah.
a 2-6 court.
my lord, 4 members put signature, actually 3-man committee.
All right, Mr. Ola,
AF and Umulla.
heard Mr. AFNU Mola, learned counsel for the petitioner. Stop. Also heard Mr. BN Gogoi, learned, you are standing counsel, Ukoban. Learned standing counsel, Ukoban. Stop. It appears that the pleadings are complete. It further appears that the records are essential for effective adjudication of the matter. List for I'll admit it and post it for hearing.
Lords.
I will put it before the records liquid. The matter requires a full-fledged hearing, then COBA records, and then post for hearing in the month of July 2024 on a date to be fixed by the registry.
Obliged, my lord.
Why is a partner, madam, regarding the disciplinary proceeding, madam?
Partnered before any other bench,
No, madam, before,
before this bench.
yes, madam. Last time the record was called for, madam.
Yes, who is appearing? Borthakur? No, sorry,
Mr. J.K. Goswami is appearing, madam.
where is he? Is Bora, where is? Sorry. Yes,
My lord, two VTs of Odali daily market,
to what?
VTs, that means two small shops, were allotted in the name of the two petitioners.
Yes.
And they have taken those two rooms on rent since last 19 years back from today. And the VTs have been also mutated in their names. Suddenly, the block elementary education officer issued a notice that we vacate the house, we will repair it from the World Bank money. So in that view, my lord, we had to, earlier we had no intention, but still later on we have vacated. Now the work has been completed. But they are not allotting the said to VTs in our names. They were asked to file affidavit for the last time, several times.
What happened? Affidavit?
No, we have already filed, my lord. They were about to take instruction from his client, man.
And what we have,
Yes, Mr. Mahmood.
we have
On 22nd, 2023 itself, I have filed.
On?
22nd,
Yes, you are R5.
yes, my lord.
Yes, R5 is fine.
Yes, and as per my affidavit, my lord, page number 3, they are already working as teachers, my lord. For that reason, they have took time for instruction.
No, which is your?
Page, my lord, paragraph 4, my lord.
perhaps
Second page.
we have not received the copy.
Why, Mr. Borthak, Mr. Datta, even your affidavit is not paginated? There is no pagination. Why were you all filing affidavits without pagination?
Maybe at that time, running page was not there, maybe.
No, running page is here, but do you have the running page?
I don't have, my lord.
Exactly. So you see, when there are running pages, it is of no good if the councils do not know the running page.
Yes, my lord.
But
I'll.
when you file your affidavits, the affidavit has to be paginated.
Yes, my lord. My mistake,
This is of 2021.
my lord.
The affidavit is filed in 2021.
23, my lord.
23
Yes, my lord.
has,
My mistake, my lord.
or is it that this court is not aware that the guidelines for filing affidavits have been changed or anything?
Oh, no, my lord.
Huh?
Not at all.
Pagination is not required anymore.
It's required, my lord.
This is the second affidavit which is before this court, which doesn't have a page. Hey, Rupak. Filing or kabak mati dibo sa na ba?
So far, my learned friend, regarding the service of the petitioners concerned. My lord,
Yes, Mr. Datta, which page?
Internal page 3, my lord.
There is no internal page marked. Anyway, I'll have to.
My lord.
Paragraph, tell me the paragraph.
Paragraph 4, my lord.
Yes,
And the next page, my lord.
yes.
2, 3, 4, 5, 6. 8 line from bottom, my lord. It starts with it may be further mentioned.
Yes.
It may be further mentioned that the petitioner number 1, Muhammad Aftabuddin Laskar, is working as BSc Maths graduate science teacher of Odali High School, and his wife Anwara Laskar, petitioner number 2, is also working as assistant teacher at Zakir Hussain LP School, so and so. Thus, it appears that the petitioners so and so, being the government employees, also took the undue privilege of obtaining settlement of betty number so and so in Odali Market Mile.
my lord, when
Initially they were.
Mahmood, you have not filed any reply to these affidavit. Are you filing a reply?
Actually, my lord.
Filing. Because these are serious allegations. These are factual aspects.
No, when the BTs were allocated in our names,
But please answer the question. Are you going to file an affidavit or you're not going to?
we'll file
You
affidavit.
can take that time. Why are you unnecessarily wasting time of the judicial time of this court? You file a reply. How can this court proceed if you don't? If your reply affidavit doesn't come, then this court is going to take the averments in paragraph 3 of the state as the correct affidavit.
Right.
If you don't wish to clarify,
No, we'll file.
then
But thing is this, my lord, when the
whatever
BTs were
the thing is,
allotted.
whatever the thing is, you have to clarify.
Yes.
A rejoinder is essential, and you had taken time earlier. How much time? How much time do you need? Mr. M.U. Mahmood, learned counsel for the petitioner, seeks 2 weeks' time to file rejoinder to the affidavit and opposition file on behalf of the respondent number 5 dated 22/12/2023. The is allowed relist after 2 weeks on a date to be fixed by the registry.
Lord, you may allow to correct the running page, my lord.
That you do whatever you want.
Yes, ma'am. My lord.
It will happy whatever. Yes.
Petition has not been represented.
We are just keeping it for some time. We'll recall. Let's see if they come. If they don't come, we'll see what is done.
I have made petitioner's advocate, my lord. Just now morning, my lord. He informed the file has been taken away from him.
Huh?
The records have been taken away from him.
But then somebody has to be. Just wait for a while, Mr. Bora. Ask him to be here. How? Mr. Bora, you know the protocol. File taken away doesn't mean the petitioner will, the learned counsel will just vanish. He has a responsibility to the court. His primary responsibility is to the court. He must be here to inform the court. Has he filed an affidavit? Has he filed it? Then
No,
saying that he has withdrawn his name. Judicial order by which he has been excused from this case.
No.
Then he's a member of the bar. These are basic etiquettes which are the members of the bar should be acquainted with. You know it very well, Mr. Bora. Yes.
The Lordship, can we take the matter after some time?
All right. All up is up. Illegal construction of boundary wall.
May it please
Yes.
the Lordships. Lordships are replies to the affidavits and oppositions are ready, Lordships. We'll file it during the course of the day.
You will file it
Yes, today, Lordships.
MSS Chakraborty,
Yes,
na?
Lordship.
Learned counsel for the petitioner submits that the rejoinder against the affidavit in opposition file on behalf of
In 16 and 18 Lordships, on behalf of respondent number 10,
All right,
In-
then you said by the respondents is ready. However, the same is going to be filed within the course of
Within
the
the
day.
course of the
Within the course of the day. In view of the aforesaid relist, when? Yes, you are appearing.
I'm appearing item number 17.
And
It's 17 is related, but slightly different.
Mr. Nath, please ask your junior to just give the appearance slip to Ms. Oberoi Loiluba. So I'm posting all of them
Yes,
together.
together.
So when do you all want it?
After we get
After a week, Lordship.
After a week. So you are going to file the rejoinder in which
Number 16 and 18 Lordships.
16 and 18 not Dibo Miss Chakraborty, Aru in 17 not Beleke Dibo, M not senior counsel assisted by Mr.
Lordship,
A-
why
A
not
Bhattacharya.
make 17 also? Huh? 17 also. I'll file my affidavit.
But I have to record your name,
Yes.
no? Mr. Assisted by Mr. A. Bhattacharya. Same prayer, Dibo, rejoinder, huh? Yes, when do you want Mr.
A
Mr.
week-
Chakraborty,
a
Mr.
week
Nath?
later, Lordships.
After a week, data that did you. Mr. Bortakpur and Mr. Roy, please give your appearances, huh?
Yes, sir. Details.
May I please?
One second.
May I please, your lordship?
Yes.
Paperless regarding illegally.
Petition of land.
Lordship, last occasion, SC revenue has taken instruction, lordship, but
Revenue?
response has not come, lordship. And other respondents have not filed affidavit yet, lordship.
Nobody has filed affidavit.
Lordship, nobody has filed.
Who are the affidavit? I think government advocate is also there.
Lordship.
Yes.
Why do we have?
We all are very quietly sitting, awaiting instructions. Nothing unusual. You must inform, you all are sitting for an invitation from the court. Yes? Are you going to file? You're not going to file? Say something.
My lord, one thing,
Huh?
my lord, this is partition is a notified service under Right to Public Service Act 2012. Now, if he approaches again,
Till here?
if the petitioner approaches again before the concerned authority with an online application, that can be disposed of within a time frame because that is time
I
frame is
think
already.
Huge disposals in that manner. You have any order with you?
Right now, I don't have, my lord.
I can take it up after some time. You give me that order.
Lordship.
You have a look. If you are agreeable to that, I'll dispose it. I remember you're right, Bhattacharya. You get hold of one. I'm sure Mr. Roy will have it.
My lord.
You just inform when you are ready.
Yes,
On a piece of paper. After some time, the petitioner counsel is on there. Demolition of illegal construction of shops.
Yes, my lord,
Yes.
and direction has been issued by the deputy commissioner at that time, my lord. After that, no action has been taken up. That order has been passed on the basis of our complaint, my lord. As no action has been taken up, therefore we approach before this honorable court in this.
Lordship, if I may produce the last order, Your Lordships.
You're appearing for whom?
I'm appearing for the respondent number 8. What has happened in this matter is that my learned friend has filed the writ petition without bringing on record the earlier writ petition which was filed on their behalf, which has also been withdrawn by with liberty to approach the civil court. Now, what was the
that affidavit?
It is. I only have annexed the withdrawal order. In
Lordship
terms of the last,
petitioner has not brought it on record.
No, Your
If your lordship permit.
I
my
have
lord,
brought it off record in my affidavit in opposition.
If your lordship permit me, my lord, I will clarify this.
No, on the last occasion, you are Mr. Alam?
M.A.I. Hussain, my lord.
Huh?
M.A.I. Hussain, Alam is my.
Having considered the above, Mr. N.K. Alam, Learned Counsel is directed to apprise The same to Mr. M.I. Hussain. That is you? M.I. Hussain is you?
Yes, my lord.
Learned engage counsel for the petitioners, although same appears to be within his knowledge.
My lord, may I clarify, my lord?
Yes.
In the earlier round of litigations, my lord, that was filed prior to certain development which was occurred.
But where have you stated all that in your
I have
petition?
stated, yes, my lord, at page number 17, paragraph 13, I have stated the case number which has been withdrawn on the basis of that case.
Paragraph?
13, my lord, page number 17 of the writ petitions, which has been withdrawn, my lord. That was I have stated.
Paragraph?
13.
1-3.
1-3. And there I have mentioned the case number, perhaps on the basis of this, my lord, they check out the order, my lord. So that issue, my lord, what happened, my lord, prior to the later developments, my lord.
Where is this order?
I have not annexed that order at that
Why?
time, my lord.
You see, this is a 2-6.
Yes, my lord.
So,
that order now
not
present.
only clean heart, clean mind, clean everything has to be. Yeah, that is the principle. You must know. Earlier it was clean hands, but later Supreme Court have clarified. Ms. Chaudhary, what is that phrase? Clean, not only clean hands.
But a clean mind and a clean conscience, if I'm not mistaken, Your Lordships.
May I clarify the thing?
Yes.
my lord?
You have to be. You see, this
That
court
is in-
doesn't know facts.
My lord.
You know the facts.
My lord.
It is on you. The onus is on you to bring
My lord.
full facts.
Yes, my lord.
Not in a half-hearted fashion.
My lord, yes.
So though you have mentioned, but this order has some relevance. Why is this order is not on record?
My lord, accidentally, I have not.
Then you
I
break
admitted-
it on record last
That is in
time.
record, my lord. That is in record.
Now you have
My
got
learned
I
senior
have got
colleague
the
has
record, but
record, my lord.
unfortunately, the order does not reflect the cause of action or the relief
My-
which was claimed in the earlier.
My lord, may I do one thing, my
My
lord?
affidavit, Your Lordships.
Uh,
It was filed on 28/8/2023. It is annexure A. Running page is page 72.
Page 70.
Page 72, running page.
Yes.
The effective portion is at page 74.
74.
Yes, Your Lordship. Now, this order unfortunately does not reflect the cause of action or the relief which was sought for.
Clarify.
may-
Exactly, let it clarify, that is all.
And one thing may be done, my lord, if the record of that or that case has been tagged with this matter, my lord, because certain letter development
That-
occurred, my lord.
that-
That
I
will
have
be
that-
better, my
You
lord.
can also.
Mr. M.A. Please write. Mr. M.A. Hussain, learned counsel for the petitioner, seeks a short accommodation to clarify as regards the withdrawal of WPC number 5257 of 2022. Stop. Before that, you say heard Mr. So-and-so for the petitioner, MS R.S. Chaudhary, learned counsel appearing for respondent number
8.
8. Anybody else?
Wait for respondent.
As
9 and
they for respondent number
9 and 10.
9 and
10.
10. As Datta for the PNRD, standing counsel PNRD. Okay. Then you say aspirate from relist after 2 weeks on a date to be fixed by the registry to enable the petitioner to file additional affidavit as prayed for. Let the matter be listed. But this is already disposed of, no?
It's disposed of.
Let the records of WPC number 5257/2022 be also tagged along with this writ petition on the next date of listing.
Hello.
Okay.
My problem. Compensation.
My lord, my senior is on legs, my lord. May I pay the matter be taken up at 2, my lord?
Land compensation.
My lord, due to construction of the overhead lines by the power grid, my lord, the petitioner hearing.
Yes, why compensation has not been given?
My lord, the question of maintainability of, the question of limitation, my lord, was not considered by the honorable district judge, my lord. And on this count, my lord, this honorable court had remanded back the matters to the London district judge for fresh consideration on that point, my lord.
Where is that order?
My lord, first.
Is not correct actually. But earlier on the earlier judgment is.
I cannot hear you, Mr. Counsel. I cannot hear you. I'm not here. Just speak in front of the mic.
My lord, pick it up at 2.
Page 38.
Page
38.
Mrs. Aiwala, you are competent enough.
My lord. My lord, before
Page
that, my lord.
38.
38.
Yes.
Relevant portion start from page 40.
This was the earlier order, my lord. This was the earlier order. My lord, for the fresh cases, your lordship had converted the same to a CRP, my lord, 227. And thereafter, the CRP was remanded back.
Where?
My lord. This was different case, but the same cause of action.
This is an offshoot from this same proceeding.
My lord, same. This is for Miss PG case 84, and the present writ petition is for Miss PG case 86, my lord.
Different.
My lord, different but similar set of cases, my lord.
So you want an order like this today?
My lord, first conversion, and thereafter, my lord, the CRP was remanded back to the honorable district judge.
Lordship may take up as 227 also, since it is filed 226. I also filed an IA for 50% compensation, lordship, in the meantime.
What happened to the other cases?
My lord, these were remanded back to the London district judge for fresh consideration on the point of limitation. After the conversion to CRP, my lord.
I'm passing this order.
Lordship.
I'm converting into 227. You want your name?
My lord, my senior's name.
Why? All right. Heard Mr. G and sir. All right, then. Can he come after some time or?
My lord, he's on legs in court number 14, my lord.
Heard Mr. G. This is the order that I'm giving, the same order. I'm only converting it. Heard Mr. G. N. Sahewala, learned senior counsel, assisted by Mr. M. Sahewala, learned counsel for the petitioner. Also heard Mr.
F.U. Barbuya.
F.U. Sorry. F.U. Barbuya.
Lordship.
Barbuya, learned counsel for respondent number 1.
Lordships, yes, 1.1 and 1.2.
The petitioner is aggrieved by the determination of compensation for drawing overhead electricity transmission line. The landowners had approached the court of learned district judge, Hailakandi.
My lord.
Hailakandi under the provision of section 16 of the Indian Telegraph Act 1885, and the said learned court had passed the impugned order.
My lord.
As per the provisions of subsection 5 of section 16 of the said act, every determination of a dispute by the district judge under subsection 3 or subsection 4 shall be final. Accordingly, the learned senior counsel for the petitioner submits that he has challenged the order passed by the learned district judge Hailakandi in miscellaneous. Please give me the number.
PG
case 86. Case number
86, my lord.
86 of
2006.
2006.
My lord.
Of 2006, huh? It is submitted that several writ petitions of similar nature are pending at various stages. Correct?
My lord.
In the prima facie opinion of the court of learned additional district judge, being a court having civil and criminal jurisdiction, is not amenable to writ jurisdiction, and the said legal proposition has been held in the case of Naresh Sridhar Mirjakar versus State of Maharashtra and others, reported in 1966, 0 Supreme within bracket SC 84, equivalent citation in 1967, 0 AI within bracket SC 1, which was decided by the apex court with a court full stop, huh? Therefore, next paragraph, therefore, notwithstanding that similar writ petitions are pending for adjudication before this court, the court proposes that the petitioner shall correct the cause title of this writ petition to convert into a revision under Article 227 of the Constitution of India, which shall be done in the presence of Registrar Judicial, and consequently, the registry shall re-register the matter as CRP,
My lord.
and list it in the admission column when?
My lord. Any date, my lord?
As early as possible.
My lord.
Rangi, there is a similar order. Right.
Deeply obliged.
Obliged.
No, no. I had to order.
May I please, Your Lordship?
Yes.
Your Lordship, in this matter, Senior Advocate H.R. Chaudhary sir will appear, Your Lordship. And he seeks some accommodation at 2 may be.
Yes, Mr. Datta, you are false.
My lord, no, it can be taken up, but we had raised an objection, preliminary objection in the case about maintainability.
Preliminary objection as regards?
Primarily on the ground of delay, my lord. And secondly, my lord, the issues that are being raised here now, that in my respectful submission cannot be gone into by the writ court, because he is asking for disputed, he is asking for compensation of damages caused to his land and standing crops. Now, the incident occurred sometimes in the year 2017, 16 and 17. So at this distant point of time, after 7, 8 years.
When did the writ petition was filed?
2023.
After almost
or 6 years.
6 years.
And when his remedy before the civil court had become barred by time. And apart from the technical objection, my lord, there is also another issue. It was a case of foreclosed contract. Now, he wants to impose on us, we were the employer in the case, he wants to impose.
We heard.
If he agrees, my lord, it can be heard, or otherwise your lordship can fix some other date. Because the legal issue would be, my lord, in my respectful submission, whether in a foreclosed contract, the vicarious liability can be enforced. And if it is to be enforced, whether it can be enforced at the instance of the writ petition.
At a belated stage.
At a belated stage.
But the land is still the possession of the company, Your Lordship.
You are for the company?
No, no,
Yes.
no. I am for the, my lord, the agency, the government agency who had entrusted the work of desiltation of the river to a company. The company has been made a party, but I think, my lord, they have not been served or they are not appearing.
Company is a party?
Yes.
Yes.
And company is in possession of the land?
Still today, Your
He
Lordship.
says so, my lord, but I have no
It is
instructions.
admittedly, Your Lordship.
No, but in that case,
Not
would the
admitted.
company's
Yes, Your Lordship.
presence not be required?
Companies in that sense, my lord. if-
R8, companies R8.
Yes. If
Respondent number 5 has admitted, your lordship.
Who is the company? Respondent number?
Respondent number
he has been made respondent number 7. I
7.
believe.
Because 8 I find is complete. 7.
8, your lordship, 8.
Oh, 8 is service is complete.
Yes, your lordship.
Right. It was made.
And
to a
respondent number
IA.
5 has admitted the fact, your lordship. Order dated 29/1 may be seen, your lordship.
Yeah, come on, you can get up.
Heard Mr.
R.A. Mazumdar.
So and so, learned counsel for the petitioner also heard Mr. S. Datta, learned senior counsel assisted by
A. Chaudhary.
Mr. A. Chaudhary, learned counsel appearing for
Respondent number 2 and 3.
respondent number 2 and 3. MSU Borwa, sorry, U Das for MSU Das, learned additional senior government advocate for respondent number 5 and 6. MS N Borderloy, right? Learned standing counsel revenue, and Mr. Goswami is also there. Stop. Office note dated 27/5/2024 indicates that service upon the respondent number 8 has been completed. However, there is no appearance or representation on behalf of the respondent number 8 till date. Think then I'll list it for hearing, admit it, or you are challenging the maintainability.
Yes.
Mr. Datta, learned senior counsel raises the issue of maintainability as regard maintainability of the writ petition. Stop. Relist on such and such date for hearing on the issue of maintainability.
It was earlier had, your lordship. 29/1 may be seen, your lordship. 29/1/2025, your lordship. Order dated. Respondent number 5 has admitted that. And we have also filed an additional affidavit, your lordship. Company is still in possession, your lordship.
All right. When do you want it?
Next week, and
No.
Hmm?
Sometimes
Next week, give a date.
maybe on 11th of June, my lord.
11 June. Okay.
Or
11 June.
Oblige.
Tuangi, bring this with the file. I'll have to see this one. 24.
25 lordships, I have not received any instruction.
It's a 23 matter. Yes. How much time do you want, Mr. Goswami?
Lords. Last, my lord, it was
sorry, Handic.
Lordship, it was listed on 24th, Lordship, 7/20. Well, we already been communicated. Well, till yet we have not received. Well, that's 3 weeks, Lordship.
All right. Mr. Chaudhary, let him get his instructions. Heard Mr. C. Chaudhary, learned senior counsel assisted by
Hidayat Sharma.
Mr.
Dr. Hidayat Sharma.
Dr. H. Sharma. H. Sharma, learned counsel for the petitioner. Stop. Also heard Mr. J. Handic, learned counsel appearing for the respondent number 5 and 6. Stop. Mr. Hendick, learned counsel for the respondent number 5 and 6 submits that that instructions are still awaited and seeks a short accommodation in the matter for filing the necessary return. Prayer is not opposed. Relist after 2 weeks to enable the respondent to complete their return on a date to be fixed by the registry. And Bodler, you're appearing? Put N Bodler for respondent number 1, 2, 3, 4.
Well, some date may be fixed, my lord. That will be better.
Some 2 weeks. Yes.
Earlier also much time was taken them.
23 matter.
My lord, this case I filed as a petition, my lord, but about 1 year back, my lord, the petitioner taken the file from me, my lord. There are a number of cases. So, my lord, I no longer have the petition.
File has been taken away from
My
you.
lord. More than, my lord, 1 year ago, my lord. I thought.
So why are you not putting an affidavit and informing? Well, an affidavit, there is nobody appearing also.
My lord, I also intimated on Saturday the party.
You see, that is of no good.
I'll, my lord.
You are an officer of the court.
I'll file, my lord.
So you inform, then your name can be struck off.
My lord.
And after that, if there is no appearance, this court will consider.
My lord.
Isn't it? Mr.
J.C. Gore.
J.C. Gore, learned counsel for the petitioner submits that the petitioner has taken away the brief from him and accordingly seeks a short accommodation to file necessary affidavit to bring the said development on record. Prayer is allowed. We list after 2 weeks on a date to be fixed by the registry. In the meantime, registry shall intimate the petitioner as regards the next date of listing. Stop and give a date, 2 weeks of the date. List on such and such.
Obliged.
My lord, both the items, my lord, has become intractable because of that one-man committee has been appointed. One-man committee has been appointed by the
One-man committee?
Yes.
All right. So, which is the writ petition? Writ petitioner filed to the auction?
Petition 819, my lord.
And what is the IA for?
IA for vacating the interim order passed in the WBC number 819, my lord.
Okay. You give this order in WPC writ petition 819 is the main?
Main.
Take 819, okay? First. Heard Mr. Alam?
Mr. M.U. Mundal. M.U. Mundal.
Sorry. Heard Mr. M.U. Mundal, learned counsel for the petitioner. Also heard Mr.
I am for the writ petitioner and my learned friend for the interlocutory application.
No, I am talking about the writ petition.
819. My friend is for respondent number.
No, in 819 you are.
819 I am the petitioner.
You are Mr.
R. Islam.
Heard Mr. R. Islam, learned counsel appearing for the petitioner. Also heard Mr. M.U. Mundal, learned counsel appearing for respondent number
6.
6 and yes. You are MS? ST? That B.O.KTH, learned counsel appearing for the corporation department. Mr. Islam, learned counsel submits that the matter has become infractious and accordingly submits that the matter in the meantime has become infractious. Stop. In view of the aforesaid endorsement made by learned counsel appearing for the petitioner, nothing survives for adjudication in this writ petition. The writ petition accordingly stands dismissed on being infractious. And make that same order in the WPC 2279 and in I 2158, you say in view of these two orders, that has also become infractious. And is any stay, if any, stands vacated.
Obliged.
Wait, please, Lordship. Lordship, I require 3 weeks further time to file my affidavit reply, my lords.
You want to file your rejoinder, Mr. Singh?
Yes, my lords.
As prayed for by Mr. J.H.
J. Singh, my lord.
Huh?
J. Singh.
J. Singh.
Yes.
Mr. J. Singh, learned counsel appearing for the petitioner, relist after 2 weeks to enable the petitioner to file rejoinder against the affidavit in opposition filed on behalf of respondent number 6 and 7 on 21/2025.
Because the state is also yet to file their reply.
In the meantime, the remaining state respondents
2 to 5.
Shall file their respective returns if they so desire.
Plus,
I've
my
given a
senior, plus my senior name can be reflected in the cost list. It's not reflected in the cost
Let
list.
the name of Mr. B.D. Kaur, learned senior counsel, be reflected in the cost list. Will I give you when listing? As paid for, I think you started. On a date to be fixed by the registry.
Okay.
That's 29.
Yes, illegal construction.
My lord. And in fact, GMC has to file an affidavit. GMD has already filed, and the private respondent are also required to file affidavit.
Only R2 has filed.
Only R2 has filed.
R2 is GMD.
GMDA.
Yes.
Mr. Esbora is on legs. He is praying for 2 weeks' time. He has not received instruction from GMC.
And what about the private respondent? All right. Heard Mr. A. Dhar, learned counsel appearing for the petitioner. Also heard Mr. You are appearing for Esbora?
Yes.
MS
J. Rajkumari on behalf
J.
of
Rajkumari on behalf of Mr. S. Borwa, learned
Bora.
Bora. Learned counsel appearing for the respondent number
1
and 2. But 2 has he's appearing for both GMC and GMDA.
Both.
And MS K. Bhorali, learned counsel appearing for respondent number 3, 4, and 5. It appears that affidavit on behalf of GMDA within bracket R2 has already been filed. MS so-and-so and MS so-and-so, both the council's names, the respondent, seeks 2 weeks time to file affidavit in opposition on behalf of the remaining respondents. Prayer is not opposed, released after 2 weeks on a date to be fixed by the registry.
The only urgency is that the building is already completed and the third party interest is being created. So an early date, 2 weeks after any date, a date may be fixed at this time.
All right, give a date after 2 weeks.
18 June. Obliged.
Matter.
Item number 20, pending item number.
Land council went to port number 3.
But why did you then inform that because of your information, the matter has been called? If councils are not here, then don't make a request to be called. Yes, next. Time being you finish the list. Once the list gets over, then you call for the time being. Yes.
Hey, please, Lordship, in this matter, pleadings have been exchanged, Lordship, but today I am feeling unwell, Lordship.
All right.
For the last 2 days, I was unwell.
Yes.
Yes, Ms. Das.
We have received one instruction, my lord. As per our instruction, my lord, outstanding dues is, my lord, 29,60,384. And as per our instruction in February, my lord, it was under process and it was in the treasury office, my lord. So probably he has received.
Lordship, that amount we have received, rest of the amount we have
My
not
lord,
received.
we have disputed, my lord, and in the affidavit.
All right,
that is
Mr.
stated.
Bhagavati is
Lord,
not
if I
feeling
speak-
well today. He's seeking a short accommodation.
My-
Ms. Das,
I thought, my lord,
sorry, Ms. Das, this is a 24 matter, and
My
just because you have your instructions.
No,
That's what I have received.
I thought, my lord, because this is our instruction, it's my duty to
No,
inform.
no,
this
that's
about-
all right. You were under the impression that nothing survived.
My lord,
But it appears, Ms.
disputed
Bhagavati.
fact now, my lord.
Anyway,
Lord,
Mr. M. Bhagavati, learned counsel appearing for the petitioner, submits that. So this one second, Rangi, don't write. Mr. Bhagavati, this instruction you have received on the file.
Lordship, out of 60 lakhs, Lordship, that amount has been paid, Lordship, rest of the amount.
So what I can do is in that case, I will record the
Lordship,
submission of Ms. Das.
Lordship.
And I will say that you will
Lordship.
take appropriate instruction on the next
Lordship,
day,
Lordship.
isn't it?
Lordship.
yes, received, yes, stated.
MS U Das, first you say MS U Das, learned additional senior government advocate for the state submits that out of
47.
submits that she submits that as per the instructions received. Yes.
My lord, may I?
Yes, yes.
60 lakhs. 30 lakhs.
You hear, Mr. Bhagavati, you hear the order.
Lordship. That's why I have the order.
Submits that submits as per instruction, na? As per instruction dated 25/2/2025, received from the office of the District Commissioner Kamrup that an amount of rupees 47,64,794 has been sanctioned, out of which rupees 29,60,384 has been paid to the petitioner, and the balance is in process.
No, Lordship.
No, man.
Lordship, 47 lakhs was for the whole lot, Lordship.
Whole work.
Not for me, Lordship.
Acha. And this 29 has been paid to Topon Kumar.
That has been paid.
Yes.
To you.
Out of 60 lakhs, 21 has been.
Sanction. But then in the order, I have said it. Mr. Bhagavati, in the order, I think I have only said that an amount of so and so has been sanctioned, out of which 29 so and so has been paid to the petitioner. And then you say full stop. Full stop. I'm not saying anything further. Mr. Bhagavati, so and so, the counsel of the petitioner seeks 2 weeks time. 2 weeks time to verify and clarify the issue, to verify the same and file additional affidavit if so required, if so advised.
Lordship, that I have received, Lordship.
No, if you see, then you are saying there is further dispute.
Yeah.
Lordship, Lordship may see the document I have placed just now. Out of 60 lakhs, that has been paid, Lordship.
Process can be proceeded.
Mr. M. Bhagavati, learned counsel appearing for the petitioner, however, submits that out of the total claim of the petitioner amount, which i.e. rupees 60 lakhs approx, only an amount of rupees 29,60,384 has been paid to the petitioner. Stop. He accordingly submits that the matter may be taken up on another date for admission hearing.
Lordship.
All right? Matter can be done, disposed of on admission date. Prayer is as prayed for, list on, yes, when?
Lordship, any day.
Next week?
Lordship.
Next week date of the day, on such and such day.
On 6th of June.
Please, you can take these documents back, you give it on the other day.
My lord, it will be in our file.
The instruction so and so is returned to MSU Das, or should I keep it on record?
Lordship.
Wait, come on. The instruction dated 25/2/2025 and the speaking order dated 30/1/2025 placed before this court by the learned counsels appearing for the parties is kept on record and marked as A and B respectively. Give your appearances.
Item 31.
X and Y codable. X and Y, not A and B.
Please, Lordship. Lordship, kindly grant us 4 weeks time to file our affidavit in opposition.
What is this matter? Land acquisition,
Lordship.
compensation.
Lordship.
Since when you are seeking compensation? Since when compensation has been deprived?
I think it is around 2024.
I think, you're not sure. You know, you're the counsel for the petitioner.
Yes, Your Lordship.
Why you think, why you're not sure? As prayed for by MSS Kemprai, Learned Standing Council KAC, relist after
4 weeks.
4 weeks to enable the council to file the necessary return in the matter. You want to file something? Huh? Relist after 2 weeks or no, not 4 weeks, 2 weeks. Make it 2 weeks. Ms. Kemprai, this court had given you 4 weeks on 19th February.
Lordship.
Still you want 4 weeks. 2 weeks. And you file it.
Lordship.
Yes.
Obliged.
Obliged. Item number 32. My pleasure. In this case, Lordship, the state side is supposed to file an affidavit. The state side is supposed to file affidavit.
Lordship, we have received instruction
Yes.
that after conducting the hearing, it was decided that they are encroachers. So we have issued that notice.
You have?
We have issued notice for eviction after that hearing.
What is the relief
They
sought?
were occupying some land which were allotted to Muchi community as Kabarstan Muchi community. So they were some of the members of the Muchi community.
Why don't you file it?
We'll have to, but these are all in vernacular, so we'll have to translate it.
No, that's right. So you file it, you get it translated, you file it. Mr. BK Talukdar. BJ, sorry. Mr. BJ Talukdar, Senior Counsel, assisted by Mr. PK Mehdi, Learned Counsel, appearing for respondent numbers
2 and 3.
2 and 3. Submits that his office has received the instruction as called for. However, seeks a short accommodation to place the same by way of an affidavit. Prayer is allowed. Yes, when?
3 weeks, man, because
list after 3 weeks on a date to be fixed by the registry. Anybody else is appearing in this matter?
Yes, ma'am. I'm paying for respondent number 4.
Please give your respective appearances. Ms. Butler, just give it to the court master. Put it in a slip and give it. Let registry reflect the name of the standing council revenue in the cause list.
Interim order.
Interim, if any, shall continue till the next date of listing.
Item 33.
Here I'm praying for another 3 weeks time to get instruction, ma'am. Instructions are awaited.
This matter.
Non-payment of bills.
Yes.
Non-payment of supply of the relief materials.
Since when?
But since this is matter pertains to 2016 and 17, but there was some inquiry has been conducted by the state authority. Subsequently, a final inquiry has been done in the month of in the year of 2024. They have submitted the reports. Pursuant to that report, my dear Lordship has also disposed of some similar writ petitions. I have annexed there. But in page number 104. Out of the same petitions. That was disposed of on 22/5/2024.
There the affidavit was there.
Yes. Let them file affidavit, man.
So, Bhattacharya, you file your affidavit. Why are you not filing?
Well, we have not received any instruction.
You get it, or otherwise we'll ask the officer to be in court. Why the bill is not paid?
The last
Ask him to be here. Because looks like it could be it is probably an admitted amount.
Yes, yes.
So there's no reason. All that you need is your instruction. It can come. You get it. I'm fixing it on Monday.
Can it be a little longer? Can it?
Why longer?
This 10 days.
Legitimate dues of litigant. Why it should be kept pending?
The last chance. 10 days.
But Friday, next Friday. You file it.
My lord.
Otherwise, failing which, I'm telling you,
My lord.
as prayed for by Mr. A. Bhattacharya, Learned Standing Council Revenue, released on next Friday, to Friday no, huh? Next Friday date to date,
On 6th June.
on such and such date to enable the revenue department to file the necessary, to file the affidavit, and or place the relevant instruction before this court. It is needless to be clarified that since the issue involved in this writ petition pertains to non-release of the contractual bill amount to the petitioner, comma, the instruction and the affidavit and or the instruction shall be positively filed stroke placed before this court by the next date of listing.
Much obliged.
I haven't said failing which, but I am telling you.
Much obliged.
Item 34.
Yes, Mr. Decker.
My lord, they're supposed to file their affidavit.
Yes, Mr. Talukdar.
Awaiting the instruction.
Awaiting instruction. How much more? How much time more?
Yes. 2 weeks, ma'am.
2 weeks. Ms. Bottler? You are also there. Are you going to file anything? Huh? So who all are going to file? Heard Mr. B. Dekal, B.D. Dekal, Learned Counsel appearing for the petitioner. Also heard Mr. B.K. Talukdar, Learned Senior Counsel assisted by Mr. P.K. Medhi, Learned Counsel appearing for respondent number
2 and 3.
2 and 3 and MS and Borderloy, Learned Standing Council Revenue. Stop. Mr. So-and-so and Mrs. So-and-so, Learned Senior Counsel and MS So-and-so seeks 2 weeks time to file their return in the matter. Prayer is not opposed. Released after 2 weeks on a date to be fixed by the registry.
Interim to win.
Interim, if any, shall continue till the next date of listing.
Obliged.
Bail hearing BA, item number 35.
Yes.
Lordship, this is a subsequent bail application, Lordship.
Earlier rejected.
Yes, Lordship. Your Honor, Lordship, the order is annexed in Annexure 6, Lordship, which is page 34, Lordship.
Yes.
This court was pleased to dismiss the same, Lordship, the initial bail application, Lordship. My only subsequent ground, Lordship, is that, Lordship, the constitutional mandate, Lordship.
22C,
Yes.
22(1).
Lordship. The grounds of arrest were never.
Is it so, Mr. Kaushik?
My lord, here arrest memo was issued to him, my lord, and the forwarding report, the grounds of arrest were mentioned, my lord. So regarding that aspect, my lord, only thing is that, my lord, recently our High Court, my lord, quoting at bench.
No, where is it?
Well, in the case that is here.
You have it?
Yes.
Sure. What is it mentioned? Is it clearly mentioned or not?
I'm showing it now. There are several accused.
You see, grounds of arrest, what is mentioned? That is important, isn't it?
Yes, ma'am.
Whatever the facts are there, it has to be, first of all, if there are more than one accused, then general facts will not do. It has to be specific, number one. Number two, the information must be so that the petitioner shall understand that, yes, this is for this ABC reason he has been arrested and for so and so offense. These basic facts are there or not? You satisfy and then you place it before the court.
That is not here. That is like.
That is not here.
That is like general.
Then.
And the forwarding report, those facts were mentioned. My lord, only thing is that, my lord, yes, my lord, that is here. But recently our High Court, my lord.
Magistrate's production order is there.
Production order is there, my lord.
What does it say?
But my learned friend has already enclosed, my lord, the production.
Page,
28, my lord.
page?
28. Oh, sorry, my lord. No, my lord, he is not enclosed in different.
Do you have it?
My lord, production order is here, my lord, in the case diary.
Yes.
What is here is, my lord, accused persons are made aware of their legal rights. On being asked, they stated that they will engage counsel of their own choice. That is there, my lord.
That's not sufficient.
That is not there.
You see, if the production order would have said that he has been informed about the grounds of his arrest,
Yes, ma'am.
that would have been sufficient.
That line is not there. The only thing is that if you also permit me,
But this arrest is when?
Lordship, this arrest was made in 2023, Lordship.
Before October or after October?
Before October, Lord.
Before October.
October, Lordship.
Huh?
In the month of October, Lordship. 2023,
Month of
Lordship.
October?
Yes, Lordship. It is.
No, that date is also very
Yes, yes,
crucial
Lordship,
because you
Lordship.
see, October is the date, October 2023, from when the,
yes, he is prior, my lord.
he's prior. So that written communication is not
Pankaj Bansal, my lord.
prior to Pankaj Bansal. So written is not required.
Yes,
But nonetheless,
yes, ma'am.
It has not been informed.
the onus is on you to show that he has been informed. Now, the arrest memo, you have been
Yes.
fairly, you have said
Yes, ma'am.
that it is not specific
Yes.
and it is not there. That apart, nothing is there. Then
No, only if your lordship permit me, I'd like to place one order of this, of our article. There are 24.
also, I would like to have a look at the arrest memo.
My lord.
Para
24. Here it was a similar thing was happened, my lord. And starts from para 22 actually.
That's why I wanted to see, I said. You see, at the end of the day, Mr. Kaushik, there's no difficulty to understand the object of 22(1), but it has to fit in the context of each case. So the arrest memo will show what is the information there. Huh? This is the notice.
Section 47.
The notice is a very general, computerized
General.
notice, no information. Then arrest memo.
Arrest memo, this one.
Huh?
There is. Prior to that,
Prior to that,
yes.
the accused concern is Tozamul Haq.
Tozamil Haq.
Lordship, it is Anash, Lordship. Mine is.
Anas,
It is
sorry,
Anash.
Anas. Oh, sorry.
Mr. Kaushik, please
I'm showing the.
Moment Anash,
put
Lordship.
the flag this side for the concerned.
Lordship, I have supplied the copy, Lordship. The notice and the arrest memo, Lordship. Lordship, if I may.
1 second. Mr. Kaushik, where are the information? You said some information are there in the arrest memo?
I'm sure about this CD, my lord, item number was wrongly placed, my lord.
There is
So
no information
here case.
except his personal identification, his name, his age,
Lordship.
nothing. Absolutely nothing.
My lord.
Huh? So why are you pressing this then?
But there was no grounds of arrest that like.
Mr. Counsel, here it says that the learned counsel for the petitioners, there is a specific finding that grounds of arrest were not served. Whereas in the present case, The scanned copy of the case records produced disclose the very existence of notice. Factual things has to be kept in mind.
Yes.
Show me, if you can show me from this documents that the reasons can be discernible, I shall be enlightened. Enlighten the court, Mr. Kaushik.
And the specific points are not.
Then
Specific-
say so. Say so. When it is not there, just say it. That is what is required, Mr. Kaushik. It is not there.
Yeah.
Nothing is there. Do you have any of the orders which this court has?
Yes, Lordship, I've annexed it. I've annexed it in my petition, Lordship.
Where?
Your Lordship, it is in page number 34, Lordship, of my petition, Lordship. The order of this.
34 is the one in your case or?
Yes, Lordship, in my case, Lordship, where it was dismissed, Lordship, by this.
No, where this court has granted?
This
Any-
co-
Where this court has granted?
Yes, Lordship. I have it, Muhammad Iqbal, Lordship.
Of this court?
Yes, Lordship, of this court, Lordship. Muhammad Iqbal, Lordship. This person was also.
Just give me a copy.
Yes, Lordship. And this. It had relied upon
Give me a.
Vihan's case law.
No. Bro.
Yeah, I will give it to you later. There's nothing.
Right, Kalpana, likha. You have seen this, na?
Yes.
Heard Mr.
Nikato, what's our Lordship?
T, right?
Nikato, what's our Lordship? N.
I'm sorry.
Nikato.
Nikato Vatsa,
Lordship.
learned counsel appearing for the petitioner. Stop. Also heard Mr. R. Kaushik, learned APP for the state respondent. Stop. This application, this is the second time.
Lordship.
The second application is filed under section 483 of BNSS 2023, seeking grant of regular bail to the petitioner I.M.D. Anas, who has been arrested on 28/10/2023 in connection with Delhi PS case number 60 of 2023, arising out of GR case number 321/2023, registered under section 21C of the NDPS Act 1985. Full stop. Pertinent that earlier. Right. Kalpana, don't say that. The brief facts of the case is that the sub-inspector of the Delhi police station, Karbi Anglong, Assam, lodged an FIR on 28/10/2023, alleging inter alia that about 10:30 p.m. upon receiving an information from IC Lahorijan PP Police Station, Delhi, regarding detention of one white color XUV 300 bearing registration number AS26E2081 coming from Manipur, suspected to be carrying drugs, and as such arrested the petitioner in connection with the aforesaid case. It is the further case of the prosecution that a total 50 numbers of soap boxes, 11 soap boxes were hidden inside the AC and music system slot, and 39 numbers of soap boxes were recovered from the right side of the rear portion of the car, collectively weighing 637.28 grams, which was driven by the petitioner. Stop. Accordingly, a FIR was registered. Pertinent that earlier, this court by order dated 29/4/2025 rejected the bail application. So then you write, Mr. N. Vatsa, next paragraph, learned counsel appearing for the petitioner submits that the grounds of arrest was not informed to the petitioner, for which his fundamental right under Article 22(1) of the Constitution of India has been infringed and violated. He further submits that, however, the said ground was inadvertently not taken up at the time of filing the first bail application. He accordingly submits that the arrest being illegal for non-compliance of the constitutional mandatory obligation, the second bail application should be allowed as prayed for. Per contra, Mr. R. Kaushik, learned APP for the state respondent, submits fairly that it is clearly discernible from the notice under section 50 CRPC issued to the petitioner, as well as the arrest memo dated 28/10/2023, that no information as regards the facts constituting the arrest has been informed to the petitioner. Correct? I have given my prudent considerations to the arguments advanced by the learned counsels appearing for both the parties, and have perused the materials available on record. The primary ground urged in this second bail application is as regards the non-compliance of the constitutional mandatory provision contained under Article 22(1) of the Constitution of India, namely the Article 22(1), Article 21 and 22(1) of the Constitution of India reads as under quote unquote. Reading of the aforesaid articles, it appears that while Article 21 protects the arrestee stroke detainee from being arrested without following the established procedure of law, Article 22(1) provides twofold protections. Firstly, it is mandatory for the arrestee to inform the arrested person as soon as may be the grounds of his arrest and his right to bail. And secondly, to produce the arrested person before the jurisdictional magistrate within 24 hours of his arrest. Therefore, it is the fundamental right of an arrestee to be informed the grounds of his arrest and his right to consult and to be defended by legal practitioner of his choice, and to be produced before the nearest magistrate within 24 hours of his arrest. This right is guaranteed to an arrestee under the Constitution of India, comma, semicolon. If it is taken away from the arrestee, it would be depriving him of his right to liberty, which being his precious fundamental right, comma, such arrest would be in total violation of his fundamental right. Within bracket or diba, refer State of Madhya Pradesh versus Sobaram and others, reported in AI 1966, Supreme Court 1910. Bracket close. Next para. Apt at this stage to produce to refer to the Section 50 CRPC notice issued to the petitioner, which is extracted hereunder for ready reference, quote unquote. Reading of the aforesaid notice, it is clear that no information as regards the ground of arrest is mentioned in the aforesaid notice. It is only his name and the case number and that he should arrange for sureties on his behalf to be released on bail is mentioned. Reading of the aforesaid, it is absolutely clear that no information whatsoever constituting the brief facts of the arrest of the petitioner is given to the petitioner at the time of his arrest. Apt also to refer to the arrest memo, which is reproduced hereunder for ready reference. Quote unquote. Be my this one. Similarly, reading of the aforesaid arrest memo, comma, similarly, it appears that except his details, no information constituting the brief facts of the arrest and or the grounds of arrest is intimated or informed to the petitioner. That being so, it is established that the fundamental right of the accused petitioner under Article 21 and 22(1) of the Constitution of India has been violated. Reference in this regard is made to the decision of the Apex Court in the case of Directorate of Enforcement versus Subhash Sharma, reported in 2025 SSE Online SE 240, wherein the Apex Court has clearly held that in the event there is a violation of fundamental right of the accused petitioner in relation to his arrest, this court has no choice but to grant bail. Paragraph 8 and 9 of the aforesaid judgment is reproduced hereunder for ready reference, quote unquote. In view of the above, Reference is also made to the decision of the apex court in the case of Vihan Kumar versus State of Haryana and others, reported in 2025 SSC Online Supreme Court 269, wherein the apex court has clearly held that in the event there is a violation of Article 21 and 22(1) of the Constitution of India, the statutory restriction shall also not affect the power of this court to grant bail. Next paragraph. In the present case, it is absolutely clear that neither the grounds of arrest, no, not say neither, that the grounds of arrest was informed. It is absolutely clear that the grounds of arrest were not informed to the accused, was not informed to the accused petitioner at the time of his arrest. Hence, the arrest of the accused petitioner is totally illegal. As such, the arrest of the accused petitioner stands vitiated. Stop. That being so, the second bail application. That being so, this the second bail that being so, the rigor of Section 37 of the NDPS Act 1985 shall not affect the power of this court to grant bail to the accused petitioner. Therefore, the detention of the accused petitioner in the custody is totally unjustified. This court cannot also be unmindful of the fact, this is not required, this part is not required. Be then as it may, in view of the facts that the arrest of the accused petitioner is illegal, this court is of the unhesitant view that the accused petitioner is liable to be released forthwith. Accordingly, it is provided bail bond of rupees 50,000.
Lordship, another thing is that he's not from Assam. The thing is that, my lord, the trial is in the last days. Out of 9 witnesses, already 6 has been examined, my lord. So one government surety should be given.
With 2 sureties of like amount, provided that one surety has to be government servant to the satisfaction of the learned trial court, subject to the following conditions: 1, 2, 3, 4, 5. Yet bail application stands allowed and disposed of. Generally, in such cases, NDPs, I always put a government.
Yes, sir.
He ordered to assess.
Obliged, Lordship.
Disposed of. Yes.
Item 36.
Start again.
Yeah, my lord, Lordship has seen this. Same, my lord.
Same.
Seen this notice, my lord.
Oh, this is that Tozamul Hog.
Yes.
Same.
Same, different case, my lord, but I am on same issue, my lord.
Where are those? Order hobo,
Yes.
This is first time or second time?
Earlier, they have withdrawn, my lord. That order I have annexed, my lord.
Yet khali pertinent korute. I think the same order will come here also. Second bill application, but second bill, the first bill. Reference to me. Reference to belek hobo. Case will be same, party khali accused or naam to belek. And arrested date this person is arrested on 7/1/2020. Okay? To add but the case numbers and everything remain same.
No, my lord.
No, different.
It is different.
Oh, the case is different.
Yes.
But why was that?
Because here my item number was wrongly mentioned, my lord. So it was tagged with that item.
That is why I'm confused, Mr. Kaushik, because you showed me in that
Yes.
case, so I thought
Yes.
it is the same case of a different accused.
Yes.
No, my
Yes,
lord.
there he was tagged with
So show that
different-
again. Ruba, Kalpana. The collective.
I have annexed, my lord, the arrest memo and notice, my lord.
Where page?
624, my lord.
Page 20?
4. certified copy, my lord, I have an 24 and 26, my lord.
Yes, it is there. Same computer format. And then
26, my lord.
same. I have given some direction in one of your cases.
Yes, my lord, the
Get
initial
it
one, my lord.
done. Otherwise, it will go on. Heard, Mr.
SM Mullah, my lord.
So and so, learned counsel for the petitioner also heard Mr. R. Kaushik, learned APP for the state respondent. This is an application under section 483 of the BNSS 2023 for release of the accused petitioner, i.e. Tozamil Haq, who was arrested on 7/1/2025 in connection with South Salmara Police Station case number 4/2025, registered under section 21B, 22C/29 of the NDPS Act 1985. So, the brief facts of the case is that on 5/1/2025, one SI within bracket P of South Salmara Police Station lodged an FIR before the officer in charge of South Salmara Police Station, alleging inter alia that on the same night at around 11:30 p.m. on the basis of secret information, the information along with the staff of South Salmara Police Station raided the house of the petitioner and recovered huge quantity of alleged contraband articles and apprehended the petitioner and one, namely Asif Ali alias Kandu, and seized the contraband in front of independent witnesses as per the seizure list. Accordingly, a case was registered. Hence the bail application. Pertinent that, yes, withdrawn order
28, my lord, please.
that this pertinent that earlier ওপৰত তুমি second bill application লিখিবা দেই first নহয় আৰু এতিয়া দিয়া pertinent that the first bail application was withdrawn by the petitioner before was dismissed by order dated 1/5/2025 on being withdrawn by the petitioner. Stop. Now, submissions will remain same, except the name will change, okay? And where I have mentioned the notice, a part put, notice to ebar 15 okoba, 47 BNSS koba. Okay? Our quote unquote page 24. Reading to same thakibo. Episode arrest memo con dated where? Where is the date of the arrest memo?
My lord, date of that has not been mentioned, my lord. That has not been mentioned. But in the paragraph serial 4, my lord, date and time of arrest is there.
No, but the arrest memo doesn't have a date.
Yes, my lord.
Where's some of it? Mr. Kaushik, just verify. I don't. Everything remains same. Huh? Otherwise, I will commit to 50,000. Childhood really quarters again, right? That is section of this is 47.
This is 47 notice, my lord.
That I have corrected.
Yes, my lord.
Arrest memo, any date is there?
Date and time of arrest is mentioned.
No. What about the arrest memo? When was it signed? When was it issued?
Below signature, there is no date, my lord.
No date.
Otherwise,
Because the arrest memo will go. Let me say date, huh? Okay. Same conditions.
Obliged, my lord.
Disposed of. Madam.
Here also, my lord, government surety, my lord, one.
Yes. Yes, Miss Hajorika, which matter?
No, the next lot. From
Down to matter.
37 to 43. Lordship, I need 3 weeks to file affidavit in reply.
You are appearing for?
For the petitioner.
Oh, you want to rejoin? You want time for
I'll file
rejoin?
rejoin.
All right. Item 37 to?
43. And 41 and 42, they have filed an affidavit. I'll file a rejoinder.
So from item 37 to 43, you want to file your rejoinder?
No, only 41 and 42.
41
Because these are all
and 42. Mr. Borthakur, you have only filed affidavits in respect of 41 and 42.
Yes, my lord, those are the writ petition.
That will cover the rest.
Okay. MS M. Hajurika, Learned Senior Counsel, assisted by Mr.
D. Khan, your lord.
D. Khan, Learned Counsel for the petitioner, seeks how much time?
3 weeks.
3 weeks time to file rejoinder against the affidavit filed on behalf of the PHE department. Stop. Mr. I. Borthakur, Learned Standing Counsel, PHE is present. Prayer is allowed. List, yes, after 3 weeks?
Yes.
List after 3 weeks on a date to be fixed by the registry. So rejoinder in respect of WPC 4631/2023 and WPC 5273 of 2023. So at order te hoye jabo. All right. Yes. Right. Timings.
Being item number 4.
Sorry, my lord, I missed that item, my lord.
No problem, Mr. Chakraborty.
My friend has told that your lordship wants to dispose it of. The issue is very small, my lord.
No,
Here,
it's not about me wanting to dispose it off. I
But,
think Mr.
yes,
Shidya was saying that it could have been disposed of. So I said that
in
get
fact, I'm also
part.
my lord, I'm also without the brief. I've taken the copy of the petition. I completely missed it, and for that I'm sorry, my lord. Here is a case, there's a boundary dispute between the district of Kabi Anglang and Nagaon, my lord. Because of sudden change in the course of river in the year 2004, and the river has divided one particular village in 2 parts, and that resulted in the villagers of the Kabi Anglang part getting unable to do something in that other side, because Nagaon people are claiming it is to be their land. So this boundary dispute has to be resolved. In this regard, my lord will see there is a
No, then this matter cannot be disposed of today.
lordship can dispose it of by directing the state government to complete the exercise they actually initiated. Lordship will have a look at page 12. This is a report of the Assistant Revenue Officer.
First of all, what have you sought for here? For
For-
demarcation.
For demarcation.
The
Resolving
prayer is for demarcation.
demarcation. And that demarcation should be on the basis of the original map of Kabi Anglang, not on the basis of the change in the course of the river. Lordship will have a look at this report at page 12. Here, one exercise was carried out. But due to obstructions created from the other's part, it could not be completed, my lord. Is a report or a letter given by the Assistant Revenue Officer to the Deputy Commissioner Kabi Anglang. Inviting reference to this office letter number under reference, I have the honor to submit the report of joint survey for demarcation of inter-district boundary in between Karbi Anglang and Nagaon district. In the time of field survey of Deputy Commissioner Karbi Anglang and SDO Hojai at village Borbil in Karbi Anglang district and Lankajan Jamunachit area, a decision was taken by the Deputy Commissioner Karbi Anglang district and SDO to conduct a joint survey boundary demarcation with Taylor staff of Donka Revenue Circle and Hojai Revenue Circle. That's sir, the dispute arose between the people of Karbi Anglang and Nagaon district in the year 2004. During the flood, the river Kopili changed its course and left approximately 40 bighas of land in village Borbil, which is the cadastral village of Donka Revenue Circle, and annual patta were issued by the authority of KSC. So, my lord, this Donka Revenue Circle is in Karbi Anglong, and the Borbil village is also in Karbi Anglong. Because of the change in the course of the river, that village was divided in two parts. And this has resulted into this problem. And when the joint demarcation process was undertaken, because of violence from the other side, it could not be completed. And that part is given. As per the decision of the Deputy Commissioner Karbi Anglong and SDO Civil Hojai, a joint survey was started by LR staff of Donka village, Lonkar Circle and Hojai Revenue Circle from so-and-so to so-and-so. But
So you want this to be completed?
yes, it completed and a permanent demarcation to take place, madam.
As per that would depend on the survey.
Yes. So if the survey is conducted and the survey should be on the basis of the area.
We can say that we can give a fixed time within which this joint survey can be completed. And in terms of that, the necessary follow-up actions to be taken, isn't it? Is that you will be satisfied? What
Yes.
about Mr. Chutia?
My lord, if your lordship look into, my lord, 6th schedule paragraph 14.
Sixth schedule
Constitution.
This is what you have referred in your paragraph 2,
My lord. Constitution. Constitution.
After consideration of the report of a commission appointed under so and so.
My lord. And that is my lord, lordship, 6th schedule paragraph 1, my lord. First,
Yes.
lordship will look into it.
Yeah.
Paragraph 1 provides that the governor may by public notification.
One second. Yes.
Paragraph 1, the governor may by public notification include any area, exclude any area, create a new autonomous district. D, increase the area of any autonomous district, diminish the area of any autonomous district. It is under E, my lord. F, unite 2 or more autonomous district or part thereof so as to form one autonomous district. Lordship will look into paragraph 14 then.
Paragraph
14. That is a procedure provided under Constitution. Appointment of commission. Paragraph 14 of the 6th schedule.
1-4.
1-4.
Yes.
Appointment of commission to inquire into and report on the administration of autonomous district and autonomous region. 1. The governor may at any time appoint a commission to examine and report on any matter specified by him relating to the administration of the autonomous district and autonomous regions in the state, including matters specified in clause D, C, D, E, and F of subparagraph 3 of paragraph 1 of this schedule. My lord, so the commission is required to be constituted, and the government, my lord, on 25th April, my lord, this commission has been constituted, my lord. So in terms of that commission, all those things will go to the commission, my lord. On 24th April 2025, my lord.
You have seen a copy, Mr. Chakraborty?
I'm having it from the person.
What is the status of the?
Well, it is only considered on 25th April 2025. Only 1 month has not yet been elapsed, my lord. The committee will function, my lord, and submit a report to the government. So this area, my lord, which the petitioner claims, my lord, whether it will diminish the area or it will be same thing like that way in the earlier boundary, it will be decided by the commission.
Nothing survived.
Survive, my lord.
But my lord,
I can simply say that let this exercise be completed within a reasonable period of time. And whatever the
outcome will take up this issue.
Whatever the outcome comes, you may be satisfied or you may have grievance.
That is,
Be that as it, in case you have a grievance, that. we'll
that
have to take
diminished
steps.
area. If that area is diminished, then it is also covered E. Diminish the area by the
All
organization.
that.
Well,
Why should we go into all?
From this notification, it is not very clear, my lord, whether the commission will take up this issue.
Mr. Chutia has submitted.
But
You want, you can verify. This is there.
there, my lord, diminished area is there, my lord. Petitioner apprehends that the area will be diminished, my lord. That will be also taken care of by the commission.
Only thing, my lord, the villagers have a very small pair. The area which was earlier
But
part
you
of.
see, this is part of the sixth schedule. It has to be done as per the mechanism provided under the sixth schedule.
Our lordship might dispose
Correct.
it off
So
by directing the
it
commission to
means
look.
that commission has to be appointed under paragraph 14, and that has been already constituted sometime in April last month. So seems it is going on. The governor may at any time appoint a commission to examine and report on any matter specified by him relating to the administration of the autonomous so and so, including matters specified A, C, D, E, and F of para 3, so and so. So that is there. Para 3, A, include any area. C, create a new autonomous district. It's there. Isn't it?
Yes, but my lord, what I feel, this issue of demarcation, what is the boundary dispute, may not be included in the scope of the commission because it says submit a report with clear recommendation for inclusion and exclusion
No,
of
but
village.
unless this is done, how can this court direct a demarcation?
Our prayer is, my lord, very simple. The joint survey, which was initiated in 2012-13 and which could not be concluded because of obstruction. Unless, my lord,
you file your affidavit, you bring this on record. If you are disputing this position, it has to be seen. Heard Mr. S. Chakraborty, Learned Counsel for the Petitioners Club, also heard Mr. J. Chutia, Learned Counsel, appearing for the respondent KACC. Na? You're appearing as standing counsel. Learned Standing Counsel KAC. Mr. So-and-so, Learned Standing Counsel KAC submits that in terms of the powers contained under the sixth schedule, in terms of the paragraph 14 of the sixth schedule, the governor of Assam has constituted the commission to identify, consider, and evaluate claims, counterclaims, objections, and demands related to the inclusion into and exclusion from the Karbi Anglong Autonomous Council KAC area under the sixth schedule of the Constitution of India. He further submits that in terms of the aforesaid notification, nothing survives for adjudication in the instant writ petition as the Mr. So-and-so, Learned Counsel appearing for the petitioner, seeks a short accommodation to take instruction as regards the same. Prayer is allowed. Relist after
2 weeks, my lord.
After 2 weeks on a date to be fixed by the registry. You take your instruction.
Timing item number 5.
No. None appears for the petitioner despite being called twice. List Friday in the column for dismissal.
Timing item number 12.
in the column orders with the remarks.
Lordship, here in this
Yes,
case, Lordship,
Goswami?
Lordship, the record is called for Lordship, but not received. Lordship, can you fix the matter in the next?
Mr. J.
K. Goswami.
Goswami, learned additional senior government advocate, submits that the records called for is still awaiting, relist after 2 weeks. After 2 weeks on a date to be fixed by the registry. I think
The pattern, man.
it's a pattern matter.
Yes.
Really, I'm releasing it. What is that then? When can you have it? The record.
Lordship, next week or
Have it next week. Monday I'm posting it.
Monday, Lordship, today, Monday. Tuesday, can it be?
Tuesday?
Tuesday, Lordship.
Tuesday ko area. Here. Make it define that the records called for is still awaited. Released on Tuesday as prayed for. Of other hearing.
Standing item 15.
Yes.
May it please your Lordship. Lordship, Mr. T. Islam was conducting this case, Lordship. He is indisposed, Lordships. Therefore, Lordships, we have collected the file yesterday evening only, Lordships. And Lordships, my name is not there, Lordships. So, my Lord, I'm praying that
You are Mr.
P.K. Gavadia, my Lord.
Your name is not there.
Not there, my Lord. I will
Mr.
procure the.
P, na?
Yes, Lord.
P.K. Gavadia Learned Council submits that Mr. T. Islam.
T. Islam, Lordship.
The engaged council has been.
He is not well, Lordships.
He is indisposed, and accordingly, he has been instructed to appear in this matter. However, since his name has not been reflected in the cause list, he could not prepare today, and accordingly, he could not prepare for the matter today, and accordingly seeks a short accommodation.
I am for the respondent number 10 and 11.
MS
MS A. Borman. A. Borman.
A. Borman, Learned Counsel for respondent number
10 and 11.
10 and 11 does not oppose to the said prayer. Relist after.
Lordships will fix it, Lordships, in the first week of June, my Lord.
Relist after 2 weeks and a date to be fixed by the
Lordships
registry.
will fix a date, my Lord.
Okay, okay.
Fix it.
Released on such and such date, June or second week, and let registry. You have signed the.
Lordships, I'll submit the Wakalatnama.
You have already submitted.
No, not submitted. Lord.
On 11th June.
Then why will your name be there? And seeks a short accommodation to file power in the matter to represent on behalf of the petition. Ripala, a second.
Standing item number 19.
May I please, I have just received this judgment, which my learned friend has already.
I forwarded to the court master as well.
Lordship, regarding this judgment, Lordship, I am allowed some time.
All right.
Lordship, let me fix on day after tomorrow, Lordship.
Mr.
B. Gohai, Lordship.
Heard Mr. B. Buragohai.
Only Gohai, Lordship.
B. Gohai, Learned B or P?
P. Gohai, Lordship.
P. Gohai, Learned Counsel for the petitioner. Also heard Mr. A. Bhattacharya, Learned Standing Counsel Revenue. Mr. Bhattacharya, Learned Standing Counsel Revenue submits that the issue involved in this writ petition is covered.
Yes.
Is covered by the judgment and order dated
31/5/2022.
31/5/2022.
Passed
Passed in
WPC 3353
stroke
2022.
In the case of
Riju Moni Bora
versus
State of Assam.
State of Assam. Mr. So and so P. Gohai seeks a short accommodation to examine the said judgment. Prayer is allowed. List
Day after tomorrow, Lordship.
Okay, list day after tomorrow.
20. Standing item number 20.
May I please, Lordship?
Yes.
The Respondent bank was asked for
Instructions.
instruction.
What happened?
As per the instruction of the respondent bank, Your Honor, the outstanding amount as on today, 11,60,000. 11,60,000. So after the payment of this amount, the bank will close the
11 lakhs?
11,60,000.
60,000. Earlier it was said 8,50,000?
50,000.
Including the interest.
No, but last order it was not said that.
No, Your Honor, Lordship, this amount is the settlement amount and settlement offer.
But last time, the learned counsel for the respondent bank shall complete her, whether fresh settlement. So according to you, if 11,60,000 is given, you are ready to settle.
Like I have to
You take
contact
it.
with my
Heard Mr.
B Fukun.
So and so learned counsel for the petitioner also heard MS.
MD.
So and so learned counsel appearing for the respondent bank. Stop. By this court by order dated 26/3/2025 directed the learned counsel appearing for the respondent bank to complete her instruction as whether a fresh settlement can be arrived inasmuch as the petitioner had paid 90% of the settlement amount to the respondent bank, and whether after payment of an amount of rupees 8,50,000, the account of the petitioner can be closed. MS so and so learned counsel appearing for the bank upon receiving instruction submits that if an amount of rupees 11,60,000, i.e. along with interest, is paid by the petitioner, the account of the petitioner can be closed. Mr. So-and-so learned counsel appearing for the petitioner seeks a short accommodation to take instruction in this regard. Prayer is allowed. List on Friday?
Yes.
Yes.
Friday.
Item number 44.
Lordship, additional affidavit is prepared and by tomorrow I will file it.
Additional affidavit is prepared.
Yes, sir. And
You will file tomorrow?
Yes, sir.
You are Mr.
D. Sharma.
D. Sharma.
Yes, sir.
Mr. D. Sharma, learned counsel appearing for the applicant submits that an additional affidavit is being prepared and the same shall be filed by tomorrow. And accordingly, 6 posting the matter on
Friday.
On such and such date, Friday date. Prayer is allowed. List on such and such date.
Highly appreciated.
Item number 45.
Lord, I have taken steps. I think the service is complete. Service is complete upon the sole respondent.
You are appearing for the sole respondent? Yes.
No, LCR has been received.
Huh?
LCR has been received. So.
12 posted for hearing. It appears that service in heard Mr. A. Day, na?
Yes, they might.
S. Day, learned counsel for the appellant, stroke also heard MS.
A. Burman.
So and so learned counsel appearing for the sole respondent. In terms of MS so and so appearing on behalf of the sole respondent, the service in respect of the sole respondent stands complete. That apart, it appears that the case records of the trial court has been received. Stop. Let the second appeal be now listed for hearing in the month of June on any date to be fixed by the registry.
Much obliged.
Item 46 and 47.
Malad, here also record come.
Record come.
Whole respondent appears.
You are appearing?
Yes, one respondent.
Same order then, except their names is different.
Advance date may be fixed.
Ahmed Koitan, Mr. J. Ahmed, Aru, Mr. S. Das, na? S. Das.
Hello. Hello.
Item number 40. My lord, steps was taken through registered post, but steps returned unserved upon the respondents.
So fresh steps.
Fresh steps may be done, but with the condition to, there is an execution proceeding filed by the defendants in the Court of Learned Civil Judge Junior Division, Baksa. So they have the knowledge, respondents have the knowledge of pendency of this appeal. So kindly fresh steps to address to that court may. Kindly steps may be served, notice may be served through Civil Judge Junior Division where in the executing court where the matter is pending between the litigants.
Heard, Mr.
A. Paul.
So and so learned counsel appearing for the petitioner.
Appellant.
Appellant. Office note dated 5/4/2025 indicates that neither AD card nor answer, no.
No, in part 2 file, my lord, in part 2 file, 2 notices have been found on, which is unserved.
This is not there.
No, no,
Office
in,
note.
in blue file, my lord. In blue file.
Hmm.
Original notice is on record and LCR has also been received.
LCR receive is there, not
in
refrain from using the word LCR, say TCR or case record. But then registry has to verify this. What is this? RSA 210 is a different RSA.
No, no, same as. There are three respondents, my lord. Notice of respondent number 1 and 3 returned, and 2 has not been returned to this court.
So this is respondent number 3.
1 and 3 returned by showing that address is not insufficient. But whereas the my lord, I have.
But where is that finding that address is insufficient? I don't find it here.
No, addresses are same, my lord, which has been found from the decree.
It says insufficient address. So you get the full address.
No, my lord, we cannot trace that because we have, they were the plaintiffs and their as per their address we have implemented as per their.
Have a look.
As per their address we have implemented.
Though office note dated 5/4/2025 indicates that the notice indicates that neither AD card nor unserved notice have been received from respondent number 2, but R2 still not received.
No, 1 and 3 is before your lordship returned.
2 is not returned.
2 is not received, returned.
Then don't say no. Office note believable. As regards 1 and 3, it appears that notice has been returned without service with the postal endorsement within quotes, insufficient address stroke, comma, return to sender. Where is it going on?
In the Court of Learned Civil Judge Junior Division, Baksa, execution proceeding.
Mr. So-and-so submits that since the execution proceeding connected to the present second appeal is going on before the court of
Learned Civil Judge Junior
Learned
Baksa.
Civil Judge,
Junior-
Junior Division, Buxa.
White case number MX
White,
9/24.
white case number,
Money execution case number 9 of
money execution case number
9 of 24.
9 of
24.
2024. He may be. You take it through that.
Yes,
court.
that's a lordship to pass the order, but then we can,
He may be allowed
allowed to serve upon the
allowed
on the
to
day of
serve
meeting.
the copy of the notice upon the respondent number 1 and 2,
All
upon the respondents
on the
on
day
the
of
next date
next day of
fixed.
proceeding. Yes,
Uh,
28/5.
I 28
5.
5 2025. Stop. Prayer is allowed. Let a report of the same be placed before this court through the Jarikarak.
No, through the junior learned civil judge.
No, there is an off that কোন থাকে court master to না থাকে কিবা এটা নাম আছে না এইটো তোমাক দেখুৱাই দিম right list after 3 weeks on a date to be fixed by the registrar.
My lord, I have to take fresh steps.
Yes.
And the registry will and collect this and to take necessary steps to serve upon them in
Yes.
the meantime.
Yes.
Okay. Item number 51.
It won't take 21. Land acquisition compensation steps.
Lordship, they are performer defendants, Lordship.
So what? You have made them.
Yes,
Why have you not taken steps? Notice was issued.
Lordship.
Are you going to take steps or I'll dismiss?
Lordship, we will take steps.
Then say that MS so and so learned counsel appearing for the petitioner commits that steps in respect of respondent number 9 and 10 as per the order of this court, as per the order dated 28/10/2024 passed by this court, shall be positively taken within a period of 3 days from today. In view of the aforesaid assurance, list after 3 weeks on a date to be fixed by the registry.
Yes.
Item number 52.
Legal occupation, yes.
My lord, this is for restoration of the writ petition, my lord.
Restoration.
Yes, my lord, it was dismissed for default on.
Where is the order?
Yeah. At annexure 1. 24/3/2025. Actually, my lord, on that day, there was a resolution by the bar to protest against the transfer of this court, and we misunderstood the resolution and we thought it is abstaining from work.
Miss,
I understand.
Counsel,
I apologize.
I coincidentally, I happen to remember
I know, my
that even even before this court,
yes, my lord, I had another matter.
there was a similar prayer made
My
on
lord,
behalf of.
3 matters were listed that
This
day.
is
my lord.
not done.
This
This is not done.
The
This
gross
is not
misunderstanding
done.
on our
Like,
part, my lord.
what kind of a misunderstanding can a council have? I have not understood. Please enlighten me. What kind of a misunderstanding can
Actually,
you
I
have?
didn't go
If
through
the
that.
bar wants to go for a strike, that is the prerogative of the bar. But
didn't
for
go-
that, the courts will be closed. For
I-
that, the courts will be closed.
My lord,
Would
no.
you not be attending the courts? What is the misunderstanding, Miss Counsel? Please tell me.
Actually, I didn't go through the resolution. That was my fault on my
No,
part.
this is not correct.
I apologize.
Absolutely not correct.
I have stated that in paragraph number 7, my lord.
In fact, on merit also, it says
Yes, some observation
that
has been
the
made.
plaint was annexed in the suit, though plaint was annexed. However, wrong plaint has been annexed without disclosing the name of the respondent number 4, who was in fact a party in the suit, and therefore there is an absolute abuse of the process of this court
This is
and
not
should be
correct.
dismissed in limine.
My lord, this is not correct. I have stated in paragraph number 8 that while dismissing the suit for non-prosecution of finding is recorded by the honorable court regarding enclosing a wrong plaint in the writ petition. However, an examination of petitioner found that the petitioner has entered the writ petition shows Tulsi Roy as defendant along with other co-defendants in this.
All right, that too.
My lord.
Here.
It's paragraph 7.
We annex this resolution.
No, my lord. Nothing was there in the resolution. It was my misunderstanding.
Sorry.
It was my misunderstanding. It was not there in the resolution.
Of course, it was not there, I know, but that is why I want to see. You see, Ms. Bhattacharya, sorry, Chakrabarti, there is no difficulty for restoration. But the principle for restoration is that you have to satisfy the court that there is a sufficient cause for which you have been prevented. Now, the cause that you are showing appears to be sheer negligence. Appears to be sheer negligence. And that apart, you know it. I don't have to tell you, Ms. Chakrabarti. You are a senior member of the bar.
My apologies for that. It was just
I don't think whenever a strike is called by any lawyer, the court is on a holiday. It has never happened. I don't think so. Correct me if I'm wrong. That never happens. There is no reason for you to have a misunderstanding. Your ground here in 7 is saying due to gross misunderstanding of the resolution adopted. So, and you have not even annexed this resolution. But what is this resolution? What is so unclear for which one could have had a misunderstanding? That is also not there before this court. In a very casual manner, it appears that this restoration is also being filed. I'm sorry, I don't see any sufficient cause here. That can't be a reason. You are pleading about the prejudice which might get caused to the petitioner, but where is your apology in this affidavit? Where is the apology?
My lord, I'll file a separate.
No, nothing doing.
Yes, my lord, this
You
is
see,
filed by the petitioner. I shall.
Ms.
Then in that case, my lord, I
Chakrabarti,
have to file separate.
these are court proceedings. These matters cannot be treated in this manner. Sometimes mistakes happen. We all are human. It happens. But that mistake has to look, it has to be bona fide, you know.
But
Now
I have just stated.
Here, you see,
fact,
I don't, yes, but how can you be so casual about it?
That's why I'm sorry.
How can you be so casual about it that there is a strike? So the court, I presume the court is on a holiday. Can a statement like this be made before the bench from someone who has put so many years of practice? Please ask this question to yourself.
My apologies.
This is not the way. This is definitely not the way. But it is very sad. It's very sad. And the contents of this also, nowhere. You cannot be playing the sympathy card of the petitioner. This court is mindful. that for no fault of the petitioner will suffer the moment this petition is not restored. But the petitioner has appointed you, and this is how you have conducted the proceedings. Petition for petition for some. This has come up for the first time.
Yes.
Respondent name is not shown. Have you served a copy to the respondent?
Respondent number 3.
Huh?
Respondent number 4. It just come up for first time today.
Yes, but the respondents are already.
Other respondents are served, man.
Huh?
Other respondents are served.
You have submitted to only government. Any private respondents was there?
Yes, private respondents is there.
So where have you served them?
Private respondent, I cannot, it just come for the first time today, man.
You don't need a notice for this. They are already part of they are already being represented in the, isn't it, Mr. Handick? This is a restoration application. Correct. And on the last occasion, they appeared when the matter was dismissed for default. Why notice is not given to them? What is this, Mr. Chakrabarti? This is not a fresh. In writ petitions, when you file IA, don't you supply a copy to the respondents? Or you wait for the court to issue notice?
But in restoration, my lord, perhaps notice will.
Why? Because this restoration is an offshoot of the writ petition being dismissed. It is filed in it is filed in writ petition. Isn't it? It is filed in this writ petition. The disposed of writ petition. Then why you have not served? This miscellaneous application has been filed seeking restoration of WPC number 798/2020, which was dismissed for non-prosecution on 24/3/2025. I'm dismissing it. Heard MS P. Chakraborty, learned counsel for the applicant. Stop. You are there, Mr. Handy? Also heard Mr. J. Handy, learned counsel appearing for respondent number 1N. This is an application filed by the applicant seeking restoration of writ petition number 798/2020, which was dismissed for non-prosecution on 24/3/2025. MS so-and-so, learned counsel for the petitioner, submits that on 24/3/2025, when the when the subject writ petition was listed before this court in the admission column, she couldn't appear before the court due to a misunderstanding as regards the resolution adopted by the bar regarding protest for shifting of the premises of the Guwahati High Court in a new vicinity. Stop. I have considered the arguments advanced by the learned counsel for the petition applicant and peruse the materials available on record. Stop. A resolution copy to uliai dibo paribo online. Mr. Hendik, can you get a copy of this resolution? I think it's possible. So please give it. Since in this restoration application, the primary ground for non-appearance of the learned counsel before this court on the last date fixed is due to misunderstanding of the resolution adopted by the bar as regards protest for the protest in connection with the issue of shifting of the premises of the High Court building, apt at this juncture to refer to the resolution dated so and so adopted by the Guwahati High Court Bar Association, which reads as hereunder, quote unquote. You got it? Can you please give it? Just give me your mobile for the time being. I can read it from there. पैसा नहीं की ना
Just forward it, Melo.
Yes, yes. Advocates Act condition.
Twenty-four.
Paisa, Advocate sir. मैं पिछले Friday में तो quote unquote लिखे तो reading of the aforesaid resolution, it is clear that it was a mere that the bar association had called for a strike
Cessation from work.
huh?
Well, I thought it to be cessation from work.
Sorry,
I thought it to be cessation from work.
that I will say uh, holding up a strike, holding a protest on 24/3/2025. The language of the resolution being absolutely unambiguous and clear. There is no there cannot be any other understanding of the said resolution. The argument of the learned counsel appearing for the applicant to the effect that she has misunderstood the said resolution to mean cessation from work cannot be accepted. Undoubtedly, the power of restoration is the discretion of this court. However, the same cannot be done. However, sufficient cause is required to be sufficient cause for non-appearance needs to be shown. Okay, stop. Yeah. However, this court cannot exercise the said discretion in a casual manner. As a matter of course, stop. It is condition precedent that sufficient cause is shown enabling exercise of discretion in favor of the applicant seeking restoration. Okay? Got it correctly now, Pranav? Pranav, Rupak মোক যে section 29, 30, 33 লাগে সেইকেইটা পালা যদি দি আছে আৰু সেই ৰিজলিউচনটো তাতে লিখি দিবা that ঠিক আছে নালাগে apt to refer to the relevant provisions of the Advocates Act 1961. Stop. Section 29, which provides chapter 4 of the said act, which provides the right to practice, which provides the right of a lawyer to practice. In chapter will go back. But in Nukoba, chapter 4 provides the right to practice. Stop word. Section 29 of the said chapter of the said under the said chapter of the said act reads as under, quote unquote. Section 30 reads as under, quote unquote. And 33. Reading of the aforesaid provision, it is clear that the right of the advocates that the advocates have dual obligations in the matter of conducting cases in the courts. Firstly, the obligation is towards their clients who have engaged them. Such obligations are subject to the terms and conditions of the contract or authority given to the counsel. For non-appearance or negligently conducting or non-conducting the cases, rights and remedies could be governed by such terms and conditions of the power of attorney. The other obligation of the advocate is towards the court as an officer of the court. An advocate is considered an officer of the court to assist the court in the matter of dispensation of justice. Such status of an advocate is recognized by passage of time by the courts. Such obligations is moral, any negligent of such assistance to the courts would be no cause for any action against an advocate. Stop. This resolution is subsequent 26.3. Where is the resolution of 24.3? This one that you have given me is the subsequent resolution. As a matter of fact, it is the noble profession that the advocates join as a privileged class. Advocates are granted right of audience in court under the Advocates Act and to conduct cases of their clients on getting remuneration for the same. Be it as it may, in any view of the matter, the ground urged for non-appearance on 24/3/2025, on which date the writ petition has been called before this court, cannot by any stretch of imagination be accepted as sufficient cause. There is no reason for the learned counsel to misunderstand the resolution, which is absolutely clear, and nowhere in which is absolutely clear to the effect that it has not requested the member of the bar to restrain from attending the court work on that date. That being so, I am not satisfied that sufficient cause has been. That being so, the application is bereft of any merit whatsoever. The restoration application stands dismissed, rejected. Sorry. It will resolution copy to an idea. Yes. 24. I need the resolution dated 24/3/2025. Did you get it? Sure. It could be 21 because probably before they may have taken it. Thank you. This is the one. Lekha, resolution dated resolution dated 21/3/2025. No, resolution adopted in the extraordinary general meeting held on 19/3/2020. देखा था? Which was circulated by notice dated 21/3/2025. Chakrabarti, very, very sorry, but you see, you have not even bothered to check all this. You see, you have filed an application seeking restoration. Restorations are not done as a matter of course. It is not done as a matter of course. Very sorry state of affairs, I must say. You have not even bothered to bring out all these facts. You are referring resolution of 23rd March, 24th March. Obviously, the resolution will be not of 24th March. 24th is the date on which there was the sit-in demonstration. How can the resolution be of that date? In fact, the resolution was not even given to you. What was given out is the notice. The notice is dated 21/3, which talks about the resolution of 19/3 and the proposed date of sit-in demonstration on 24/3. And it was only a sit-in demonstration from 11 to 2. That's all. Nowhere. And this is not correct. Absolutely not correct. In order to edit করে দিম এটু তেওঁৰ পৰা লৈ লওকচোন আৰু এটু print to edit দিব please provide thank you for your assistance dispose of
Item 53. May please, Lordship.
53 oh
Lordship could say.
এই মাত্র এটু কোনটো আছিল আইনৰ নম্বৰটো 52 না yes what review you want
Lordship, earlier some vital aspect was not pointed out by
review is not rehearing Mr. Counsel
no, by the previous council, not rehiring Lordship, but because of the fault.
but review is not also for that review is the power of review is well settled.
If I may rely upon.
Review cannot be rehearing or because
Yes,
some
yes.
council has not has placed some certain things.
If I may rely upon.
For that you can go for
We filed an appeal, Lordship.
this come on the first day.
Yes, first day.
Notice then. Now.
There was a dismissal from service, Lordship. Paragraph 87. This is BCCI.
On what point?
For review, Lordship. Whether what I am saying.
Page para?
Paragraph 87, 88 and 89.
80?
87. At page 16.
87 and?
88, 89. If I may read, Lordship. We are furthermore of the opinion that jurisdiction of the High Court in entertaining a review application cannot be said to be explicit in law. Section 114 of the Code empowers the court to review its order if the condition precedents laid down therein are satisfied. The substantive provision of law does not prescribe any limitation on the power of the court, except those which are expressly provided in Section 114 of the Code, in terms of whereof it is empowered to make such order as it thinks fit. 88. Order 47, Rule 1 of the Code provides for filing an application for review. Such an application for review would be maintainable not only upon discovery of a new and important piece of evidence, or where there exists an error apparent of the face of the record, but also if the same is necessitated on amount of some mistake or for any other sufficient reason. Thus, a mistake on a part of the court which would include a mistake in the nature of the undertaking may also call for a review of the order. An application for review would also be maintainable if there exists sufficient reason.
Issue notice. Any private party?
No, Lordship. Department of Home.
You're appearing for all?
My lord, actually, additional senior government, he is on legs in court number 7.
I'm only issuing notice right now.
J.K. Goswami, sir.
You file your objections, if any.
Right.
Are you going to accept? Are you a junior counsel?
I'm simply panel advocate.
You are a panel advocate.
Yes.
So then I will, Mr. J.K. Goswami, learned additional senior government advocate, accepts notice on behalf of the state respondents, extra copies to be served within the course of the day or 2 days.
3 days.
3 days from today. List after 2 weeks on a date to be fixed by the registry. This you take back on that day you give.
Obliged.
54.
Into ঘুরাই দিব।
May I please, your lordship? Lordship, in this writ petition, I have filed an
Just 1 second, Pranav. The order file please বললে না বাকিনি কইলো। Yes, why is this what do you want amendment?
My lord, this I is for amendment of the writ petition, my lord. My lord, first of all, lordship will kindly allow me to explain the facts, my lord. My lord, in the month of June 2022, from 4th June 2022 to 20 June 2022, a total amount of 3,71,295 had been stolen from the bank account of the petitioner, my lord. By several.
Mr. Counsel,
My lord.
you can submit slowly.
My lord. And the amount was stolen, my lord, by several unauthorized and illegal transactions, my lord. All were online transactions. And no SMS alert had been received by my client, my lord, in her registered mobile number with the bank, my lord.
You want to now amend what? The writ petition?
Yes, my lord. My lord, due to an inadvertent mistake on my part, my lord, I failed to make the Bharti Airtel Limited, that is the SIM card provider of the petitioner,
a party
in the case, my lord.
So you want to add them?
No, I want to add them as a party, my lord. And furthermore, my lord, subsequent during pendency of this writ petition, some further documents had been received by my client, my lord, which indicates that there were insufficient. There were insufficiency in the investigation carried out by the police, my lord, on the FIR filed by my client, my lord.
All right.
My lord, those additional documents are at page number. Page number 20 and page number 25, my lord. Page number 20 is the final report submitted by the police after an improper.
Page number 20.
Page number 20, my lord.
Yes.
Page number 20 is the final report submitted by the police.
20, right?
Yes, my lord.
Yes.
Page number 20.
Final report.
Final report, my lord.
Yes.
This final report was submitted by the police without properly investigating the case, and this final report was placed before the learned lower court for consideration, my lord. But the learned lower court has rejected this final report of the police with an instruction to the investigating officer to conduct further inquiry involving
This is at page 25.
Yes, my lord. At page number 25 is the order passed by the learned special judicial magistrate Assam, my lord.
You just read that perusal of the case diary part at page 25.
Yes, my lord. I am reading, my lord. Perusal of the case diary, it reveals that there is a scope for further investigation in the case, and thus I deemed it fit to reject the final report and direct the OC of the dispute PPS to conduct further investigation into the allegation against the accused person by entrusting an IO having technical expertise to investigate cybercrime cases, or the OC dispute PS may consider transferring the case to other police station having the technical expertise and exclusive jurisdiction in cyber related offenses. Send back the CD to OC dispute PS, my lord. My lord, now I want to include these documents as a part of the record of the case, my lord. As in the prayer of the writ petition, there is allegation of
What is your prayer in the writ petition?
Yes, my lord. I'm coming to the prayer. My lordship will kindly come to page number.
You be relaxed, Mr. Counsel.
Lordship. Lordship, kindly come to page number 16, my lord.
Page number?
16, my lord, of the writ petition.
16.
Yes, my lord.
Yes. Yes, please.
Yes, my lordship. I am reading the prayer portion. In the premises aforesaid, it is therefore most respectfully prayed that your lordships may be pleased to admit this petition, call for the records of the case, and further be pleased to issue rule calling upon the respondents to show cause as to why an appropriate order or direction shall not be issued to respondent numbers 4 and 5 to reverse the aforesaid amount of rupees 3,71,295. Secondly, an appropriate order or direction shall not be issued to the Director General of Police, Assam, Ulubari.
I don't find exactly what you're reading here.
Lordship, the
Page 16.
Yes, page 16, my lord. 16.
Page 16 of the
writ petition, my lord.
Oh. Writ petitioner filed a document, Tahiri Rupak. Coincidentally, your in the amendment application also the prayer is at page 16.
My lord, yes.
So I was reading there. page 16.
Yes, my lord.
Yes.
Merely read Lordship.
Yes, yes.
In the premises aforesaid, it is therefore most respectfully prayed that your Lordship may be pleased to admit this petition, call for the records of the case, and further be pleased to issue a rule calling upon the respondents to show cause as to why an appropriate order or direction shall not be issued to respondent numbers 4 and 5 to reverse the aforesaid amount of rupees 3,71,295.
Any objection if this amount about the amendment can be amended for effective adjudication?
Lordship.
Your name?
My lord, S. Vikas.
Heard Mr. S. Vikas, learned counsel appearing for the applicant. Stop. Also heard Mr.
K Das, your lord.
K.
K
Mr.
Das, yes.
K. Das, learned counsel appearing for respondent number 4 and 5.
Yes, lord.
And Mr. S. P. P. Hajorika, learned counsel appearing for the respondent number 3. And Mr. J.K. Hendick, learned counsel appearing for 1, 2 and 6. 1, 2 and 6. By way of this application, that you, if required, you subsequently file an impleading and you implead the additional.
My lord, I will file it.
Because right now in this IA, it is only for amendment. I can allow this amendment. Isn't it? By way of this amendment application, comma, the applicant is seeking amendment of the writ petition IWPC number 6523/2023. The brief facts of the case is that while filing the said writ petition, or you may just copy this paragraph 2 as the brief facts of the case. Paragraph 2. Then next paragraph. Paragraph 2 at page 4. Then say, it is the specific case of the applicant that while filing the aforesaid writ petition, an inadvertent error occurred whereby the Bharati Airtel Limited, i.e. the telecommunication service provider that issued the petitioner's prepaid SIM card bearing mobile number 8811882814 was not arrayed as a party respondent in the writ petition. It is the further case of the applicant that certain vital informations which has an important bearing in the writ petition was also inadvertently not pleaded.
My lord, documents were received during penancy.
Was not, could not be pleaded as the documents in connection to these informations was received subsequently. Accordingly, the present amendment application has been filed. Mr. So-and-so, learned counsel for the applicant, submits that since the documents have been subsequently received, the same could not be made part of the writ petition. He, however, submits that since the documents has an important bearing for the effective adjudication of the list in hand, it is necessitated that the amendment sought for be allowed. In the allowed, full stop. Mr. So-and-so and Mr. So-and-so and Mr. So-and-so, learned counsels appearing for the respondents, fairly submits before this court that they have not received any instruction to oppose the prayer of amendment. Correct? Yes. I've heard so-and-so. Huh? It appears that subsequent to filing the WPC number 6523 of 2023, certain new developments have occurred. Number one, the petitioner has obtained certified copies of the police's final report in Dispur PS case number 1756/2022. Stop. The petitioner has also obtained the certified copy of the order dated 1/8/2024, passed by the Special Judicial Magistrate Assam Guwahati. Is the date mentioned when you had obtained these certified copies?
Proceed, no, my lord.
Stop. A perusal of the aforesaid certificates, it appears that the final report submitted in Dispur PS case number 1756/2022 was set aside by the magistrate court. That apart, the petitioner inadvertently due to an inadvertent error did not add Bharati Airtel Limited as a party respondent in the writ petition. It appears that Bharati Airtel Limited is the telecommunication service provider which issued the petitioner's prepaid SIM card. Relevant paragraphs of the amendment application is reproduced hereunder for ready reference. 3, 4, 5, 6, 7, quote unquote. It appears that in order to effectively adjudicate the writ petition, the aforesaid facts are essential and necessary. That being so, the amendment as sought for is allowed. Accordingly, it is provided that in the cause title of the case on page number 4 of the writ petition, after the words within quotes, now this you copy from page 11, till A to A. Okay. That you make as 1, first part. It is provided 1 or Roman 1. Then Roman 2. In the paragraph number 3 on page number 6 of the writ petition, after the sentence B to B, page 11. Okay. Number 3. In after the paragraph number 9 and before the paragraph number 10, on page number 13 of the writ petition, the following new paragraph number 9A be added. Quote unquote C to C, page 12. In paragraph number 10, on page number 13 of the writ petition, the following sentence be deleted, for the same has become be deleted. So this I am not giving. Deleted is not giving. Let that be there. I don't say this. After paragraph 10 and before paragraph 11, in page 14 of the writ petition, the following new paragraph number 10A may be added to the writ petition. D to D, page 11. This is a long page, D to D, and it goes on till page 17. Let a copy of the amended petition be submitted before the registry for doing the needful. Application stands disposed of, allowed and disposed of.
Highly obliged.
55.
Correction.
Minor correction, my lord. My lord's order is at page 15.
In bail.
The bail application, my lord.
I look important.
IA. No, this is an IA, but for correction of a bail order.
Not bail.
What is the mistake?
In place of district and session judge, it should be additional session charge. My lord will find the.
All right.
Paragraph 15.
Heard Mr. Ian Srinivasan, learned counsel appearing for the petitioner. Also heard Mr. KK Das, learned APB for the state respondent. Stop. This is an application seeking correction of a typographical error in the order dated 29/4/2025 in bail application number 1010 of 2025. It appears that in the order dated 29/4/2025, inadvertently, the name of the trial court. The name of the trial court, no? The name of the trial court has been mentioned as District and Session Judge Sri Bhumi, Karimganj, instead of Additional Session Judge Sri Bhumi in paragraph 15 of the said order. Okay? Put this in quotes, huh? District and Session Judge Sri Bhumi, Karimganj, and then Additional Session Judge Sri Bhumi in quotes. In the interest of justice, the order dated 29/4/2025 is corrected by inserting the words Additional Session Judge Sri Bhumi Assam in place of District and Session Judge Sri Bhumi. Only in one paragraph.
Only one.
In paragraph 15. Allowed, disposed of. I don't think I need to quote 15. So the order dated, then this order be treated as a part of, I think that should be required to be treated to be a part of the order dated 29/4/2025.
Supplementary list item number 56.
Right, 2,902 days delay.
Yes.
Yes.
You know what happened in this case? The appellant of the original second appeal expired. So while filing the petition for abatement and substitution, there was some delay. In delay, the report came with regard to respondent number 4 and 6 from the Gaubura that they already expired. So we have to file abatement and substitution of respondent number 4 and 6. And from the report that came along with that of the report of the Gaubura, we could detect that for respondent number 4, there was a delay of these days, and respondent number 6, there was a delay of 1,960 days because they expired and we were not aware of it. It came along with the report. And so notice was issued and it was solved also. In response. Respondent number and respondent number 6A260.
What about the others?
Others were with regard to 4 and 6. There was.
Do you have any objection? You don't have any objection. Who are the other respondents?
Respondent number 1 is actually.
Any objection for the condemnation?
No,
it's up to you. The delay is 2,900.
You know that with regard to respondent number 4 and 6, original delay, they have filed objection.
Achha.
This is only with regard to substitution of respondent number 4 and 6.
Substitution of respondent
Number 4 and 6 with their legal heirs. So notice has gone with regard to that delay petition with regard to respondent number 4 and 6 to the legal heirs.
This is 2,996
and 2,997.
2,996
and 2,997.
1 second. 2,996 and 2,997. This is also again substitution. 2,997 is for?
2,996 and 2,998. Apologize, 2,996.
Both are delay condonation.
Delay with regard to respondent number 4 and respondent number 6. Notice was issued.
So 2,996 is with regard to which?
No, respondent number 4.
R4.
R4.
And 2,998 is
R6.
6. And both are 2,902 days.
Yes, with regard to substitution of their legal heirs.
And where is the ground mentioned here in the condemnation application?
Yes. Delay. I'm reading 2,996.
Yes, please.
2,996 at.
Yes, please.
Yes, from paragraph number
5.
3.
Paragraph 3.
3. that, may I read?
Yes, please.
That the applicant number 1823456 and 7 have filed an IA civil number 1185/2024 on 8/4/2000.
You are Ms. Barwa.
My lord.
Yes, Ms. Barwa.
8/4/2024 for condonation of delay and IA civil number 1186/2024 on 8/4/2024 for setting aside the abatement and IA civil number 1187/2024 on 8/4/2024 for substitution of legal heirs of the deceased appellant, that is Suren Gogoi. And when the above referred interlocutory application came up before the Honorable Court on 15/5/2024, the Honorable Court vide order dated 15/5/2024 issued notice upon the respondent defendants of RSA number 260/2016, who are also the respondents in the above referred three interlocutory applications. That on 31/7/2024, when the matter came up before the Honorable Court with regard to service of notice, with regard to above referred interlocutory applications, a report with regard to respondent number 4, Debiram Hazong, was submitted by the government Gaubura, dated 26/2024. The respondent defendant number 4 expired 8 years back. That thereafter, the applicant from the record of the Honorable High Court submitted by the government Gaubura, dated 26/2024, came to knowledge about the death of respondent defendant number 4, and thereafter the applicant number 5 went to meet the Gaubura of the village, who informed him about the truth that Debiram Hazong expired 8 years back.
There is sufficient explanation. Okay, I'm condoning. Yes, this order is in IA Civil 2996 of 2024. Okay. Heard MS S.G. Barwa, learned counsel for the applicant. Stop. Also heard MS P. P for Punjab. P. Barwa, learned. You said you are a legal aid counsel. Learned legal aid counsel. Learned counsel appearing on behalf of respondent number 4. 4A to 4E. And respondent number 6A to 6E. Stop. And are you also appearing in this case? In 2996?
No, they are not.
Please not. Okay. The facts of the case is that the brief facts of the case is that the present interlocutory application has been filed for condoning the delay that has occurred for filing substitution application in respect of the legal heirs of the deceased appellant, I. Shri Suren Gogoi, I. Respondent number 4.
With due respect, with regard to deceased Suren Gogoi, when the IO was filed for substitution, notices were issued.
In the substitution application, isn't it?
Yes, Your Honor.
Yes, tell me.
What happened was that in the appellant of the present case, he expired. So we filed a petition for there was delay.
This order you take, let Bhargav do it. You type the other one. Okay.
You know what happened was that in this case, the appellant expired during the COVID phase. So we can
just one sec. Shwangi, just give him the first part. Just tell him the first. Yes.
So you know, with regard to the appellant, we have to file substitution and abatement. For that, there was a delay. So in that delay, there was a delay. And that delay petition is pending. When we serve notice upon that delay petition, Your Honor, I have referred 3 interlocutory applications at paragraph number 3. Your Honor, may kindly see there are 3. So we send notices to the original respondents of the second appeal. While a report came in the, Your Honor, the next page on 15/5, Your Honor, on 31/7.
No, right now you want to, I've understood,
Yes.
but right now the substitution, this condonation that you are seeking is for substitution of the deceased appellant.
This is respondent number 4 and 6.
Respondent number 4.
4 and 6 of the.
I will say 4 in this. In the first one, I'm concerned with 4 right now.
The second 4. Your Honor, it will be 4.
And his name is
Debirang The four is Debirang Tarong, no, four, yes, your name?
Devi Ram.
Devi Ram.
Okay, all right. You hear it out. Now you hear it out, okay?
My lord.
This, Uporkini Paisa na, heard so and so. Absolutely. This condonation application has been filed seeking condonation of 2902 days which have occurred in filing the connected subsequent application for substituting the legal heirs of late Debiram Hajong. I respondent number 4 in the IA. No, he is not a respondent.
You have respondent number, your
Four
name
is where?
Four, you can, your name makes, kindly say four of the original appeal.
In the original second application, appeal.
My lord.
In the original second appeal.
My lord.
No? Stop. MS Burwan, Learned Counsel submits that the delay has primarily been occurred as earlier the applicant was unaware of the demise of Debiram Hajong. And hence the substitution application couldn't be filed in within the period of limitation as prescribed under the Limitation Act. Stop. MS so and so, Barwal, Learned Counsel, appearing for the respondent number 4, submits that she has received no instruction to oppose the prayer of condonation. Heard, perused. Apt to reproduce paragraph 3 to paragraph 7 of the condonation application for ready reference, quote unquote, page 7 of Rapaba. Reading of the aforesaid grounds, it appears that the delay is not intentional, and the grounds urged in the aforesaid in the application appears to be sufficient and bona fide. That being so, the delay condonation application stands allowed. Delay of 2902 days stands condoned. Disposed of, allowed for it. Next IA to dear. This goes in the first IA, that is IA number 2996 of 2024. It to hold item 56. Next to Loba, IA 2998 2024. Petitioner applicant or Nam Tikrokoba Borwa. Here respondent will be
No, same here.
Barwa.
Same.
Respondent number 6.
6A to 6E.
Now it will be 6A to 6E. Okay. Respondent. This interlocutory application under Section 5 of the Limitation Act has been filed by the applicant in IA number 1185/2024 for condoning the delay of 1960 days.
My lord.
1960 days in filing the application for setting aside abatement on death of respondent number 6 and for substitution of legal heirs of respondent number 6. Correct?
My lord.
Stop. MS so and so, Learned Counsel for the petition applicant that was not aware or later on company. Ticketor submission to Ekikoba, no instruction kite. তাৰপিছত যোনটো paragraph দিছিল কি আছিল সেইটো ইয়াত দিবা 3 to 7 3 page 7 of আৰম্ভ হ'ব yes 3 to 7 and তাৰপিছত বাকিখিনি same. Delay to 1960 আৰু response number 6 R4 নহয় ইয়াত খালি সেই নামটো যদি ক'বাত আছে order here it is Subol Hajong না
Subol Hajong.
এটোত মই অকমান ওপৰখিনি বেলেগ কৰিলো সেইকাৰণে নামটো মই পোৱা নাই
Then there are two IS. These are for abatement.
These two are let first anyway I think that can be taken up later on.
Yeah, no. Abatement and substitution is there.
Those are because
R4 and R6 only.
R4 R6
because delay was not gonna, so abatement now then delay was gonna.
those in view of when do you want it?
Any day.
List.
One submission, my friend, I came to know now only my friend see because she will be on maternity leave, advanced stage. So if it can be on coming week, she has stated she will not be able to come.
You want next week? You don't want next week?
She wanted because she's in advanced stage. She will not be able to come.
Now, which this order needs to be passed in which IA?
This abatement and substitution in IA number 2997, 2999. Abatement and 3000 is substitution.
That can be disposed of today also.
That was what I was saying.
Sound the option 2997 to diok agote 2997
is for abatement of R4.
2997 on MS S Borwa ekhetor naam to di diba R4
997 R4.
This application is filed under order 22 rule 9 for setting aside abatement. For setting aside
abatement.
I'll allow it. Huh? But so here also the
same because you're not
four correct
delay only same.
Correct. So this is actually where I just condone the delay.
Yes,
that is 2998.
Yes, Yona, that is what I was saying.
Okay. The facts of the case is that
Yona, para 7 might come up since delay has gone. Hello.
Paragraph?
Your Lordship, paragraph number 7 may come up now because the other part are same with regard to delay.
That in RSA number 260/2016, in view of the death of the respondent defendant number 4,
my lord,
right to sue survives upon the legal heirs of the original respondent defendant number 4, and unless and until abatement has been set aside, the legal heir of respondent defendant number 4 could not be substituted as respondent number 4A, 4B, 4C, 4D, and 4E in the regular second appeal. Accordingly, the said application for setting aside the abatement in the original for setting aside the abatement of which order?
Set aside the unity.
Abatement passed where?
In IA case number 2998/2024.
In IA? Please give me that because it is not referred here.
You know, with regard to R4, it is R2997.
Huh?
No, the original order is IA 2998.
I have 2997. I have IA 2997 You want to set
Your,
aside,
it will be, the notice was issued in IA number, actually 3 IAs notice were issued.
Ms.
in-
Counsel,
Yes.
you want to set aside the abatement order.
Yes.
Where is that order?
IA 1185
You
2020.
have a copy of that order. It should have been annexed here. Because you want to this court to set
Yes.
aside that order.
Yes.
Why have you not annexed? So,
1185.
1185.
It was for condonation of delay. In which the notice was issued.
So but you want to set aside what now?
I want to set aside the abatement so that substitution can be done.
Correct. Now that abatement is where? Where
In
was
one-
the abatement?
1185 2024, IA one, in which notice was issued for condonation of delay for
Ms.
substituting.
Counsel, I think I'm not making myself clear to you.
You know, I'm understanding.
You want this
Yes.
court to set aside an abatement order,
Yes.
right?
Yes.
There has to be an abatement order.
Yes.
Where do I get that abatement order?
That.
Just give me the abatement order.
My abatement order is to, no.
Anok.
No. Abatement order is not passed, Your Honor, because
Then why?
notice was issued.
No,
Your Honor,
because you see, what you have said is unless and until
un-
abatement has been set aside. Now, where is what is to be set aside then? Hearing the parties further be pleased to set aside the abatement.
Yeah, because you're not for the substitution, the abatement has to go. So for substituting the
Abatement has to go, that first there has to be an order of abatement, no?
no order of about no, Your Honor.
Then
Because limitation as per the limit.
that is for.
Yes, I understood, but no order was passed.
Then what is to be set aside?
To
What
with
do
regard
you want me to set
abatement
aside?
with regard to the delay in filing the
No, you are not being able to.
Your Honor may take up
The lists on Monday.
Monday.
Monday koida baki.
Monday.
Second.
I understood.
Item number 57.
May I please, Your Lordship? This I is for early hearing, Lordship.
Huh?
This I is for early hearing.
Early hearing of what?
The main appeal, Lordship.
Huh?
Main appeal, RSA number 59 of 29.
Early hearing of a second appeal.
Yes, Lordship.
What is the ground of early hearing?
Your Lordship, actually, the appellant hearing is a differently able person, and he's also a senior citizen.
Appeal is RSA is of which year? 19.
2019, Lordship.
Okay, allowed. You are FN Jaman.
No, Lordship. B. Hazorika.
Heard MS?
B. Hazorika.
B. Hazorika, Learned Counsel for the applicants. This interlocutory application is preferred. Notice was issued.
Yes, Lordship. Notice was issued, but they are not appearing.
No.
In main appeal also, we have issued notice. Lordship.
Counsel. The office note says no service report has been received from respondent numbers 1, 2.1 to 2.3, 325, 6.1, 6.2, 6.12, 7 till date.
Yes, Lordship. But
Moreover, no step has been received for issuance of notice upon the respondent till date. You have not even taken steps.
we have taken by usual process, Lordship.
Nay,
In
it doesn't
RS,
say.
so we have taken steps, but they are not appearing, Lordship.
You are, but the notice was supposed to be issued by both registered post with AD and by usual process. Where have you taken steps for registered post?
Lordship, we will take steps.
Take it.
No.
I would have otherwise disposed it. But they are not appearing in the second appeal.
Yes, Lordship. They are not appearing also in second appeal.
Anyway, as prayed for MS so-and-so, as prayed for by MS so-and-so, Learned Counsel appearing for the applicant, matter stay adjourned for 2 weeks to enable so-and-so to take the requisite steps in respect of issuance of notices upon the respondents as directed earlier by this court by order dated 28/3/2025. Stop. তার উপর আমি প্রস্তাব কবা office note dated 22/2/2025 indicates that no steps by registered post with AD have been received by the office till date. MS so assures that fresh steps shall be taken within a period of 3 days in terms of the order dated 28/3/2025 in respect of the respondents by registered post with AD within 3 days from today. In view of the aforesaid assurance, list after 3 weeks on a date to be fixed by the registry. What? Ms. Barwa, you
Your Honor, I have seen the provision. Actually, Your Honor, I may be wrong. Your Honor, as per section limitation act, if 60 days over, the suit becomes automatic withdrawal. As per 9(2), Your Honor, I don't think 9.
So this is an automatic abatement.
I may be wrong, but as
No,
per
no,
my
you may be right. That is what I'm asking.
That
So-
was I was.
Yes, because when you're asking for setting aside an
Yes.
abatement, there has to be
Yes,
somewhere.
because after
If
60
there is a
days-
deemed provision of an abandonment, then
Yes.
that has to be placed, no? Rule 9.
9(2), subsection 2 continues to 3.
Rule 9(2).
9(2), and it goes to 3 with regard to limiting 60 days.
The plaintiff or the person claiming to be the legal representative of a deceased plaintiff or the assignee or the receiver in the case of an insolvent plaintiff may apply for an order to set aside the abatement or dismissal. And if it is proved that he was prevented, that is in case of an abatement, but effect of abatement, where a suit abates or is dismissed, no fresh suit. Now, where does it abate? Where does it says that it automatically abates?
I will, on Monday, I will clear
Yes,
everything and
you
come.
clear that part.
Yes, yes.
If there is a deemed abatement,
Yes,
because
I understood logic. I
see the here it is a defendant, na?
Defendant.
Rule 2. Where there are more plaintiffs or defendants than one, and one of them dies, and where the right to sue survives to the surviving plaintiff or plaintiffs alone or against the surviving defendant or defendants alone, the court shall cause an entry to that effect to be made on the record, and the suit shall proceed at the instance of the surviving plaintiff or plaintiffs or against the surviving defendant or defendant.
Yes.
But an order has to be there. Now, procedure in case of death of, that is plaintiff, we are not. Procedure in case of death of one of several defendants or of sole, where one of the, or two defendant dies and the right to sue does not survive against the surviving defendant or defendants alone, or a sole defendant or sole surviving defendant dies and the right to sue survives, the court on an application made in that behalf shall cause the legal representative of the deceased defendant to be made a party and shall proceed with the suit. Any person so made a party may make an appropriate so and so, where within the time limited by law no application is made under subrule 1, the suit shall abate as against the deceased defendant. This is what you are trying to say.
Yes.
Because since you were unaware, you could not make that application within subsection 1 of 4.
Yes, within time.
Therefore, it after the expiry of the time frame, the suit was abated against respondent number 4 and in
Six, yes.
and in another case 6.
Yes.
And now that is why first you sought for condonation, which this court have allowed, and in the subsequent 2 applications you are seeking for
Abatement and
one is for abatement and setting aside the abatement,
abatement.
and the second is for substitute.
Yes.
I get it. Okay, I'll dispose it right now. I shall not disturb you on Monday. You can rest on Monday. Sit, sit. Why are you standing? Sit. Miss Barwa, you can also take your seat. Rubo. Bill Marilarigo.
2997.
Heard MS S. Barwa, learned counsel for the appellant. Stop. Also heard MS P. Barwa, learned counsel appearing for respondent number 4. Here 4 now in 29974, right?
Yes, yes.
This is an application seeking setting aside of the abatement of the respondent number 4 in the original regular second appeal. Correct? Stop. The brief facts of the case is that in the original second appeal, after the death of the respondent number 4, since within the prescribed time, no application for substitution of the legal heirs of respondent number 4 was filed, the appeal was abated against the respondent number 4. However, subsequently, the applicant having come to know that the respondent number 4 has expired, and after obtaining the details of the legal heirs, have filed the instant application for setting aside the abatement. Stop. MS so-and-so submits that the grounds urged in this application are sufficient and are sufficient cause. Stop. Heard, perused. It appears that on the death of the respondent defendant number 4, in the regular second appeal, actually this death was in the appeal or suit?
Actually, in the appeal stage, we came to know, but what I could say,
That was
yes,
is the original suit.
And in the judgment, there was no such even appreciation of that. That was I was, it didn't came to knowledge since a long period. Only on that it came to even
That the defendant number, it appears that the defendant number 4, respondent defendant number 4, in the original, in defendant number 4, had expired during the pendency of the original suit, and however, he being survived by his legal heir, comma, the right to sue survives, and accordingly, the instant application has been filed for substituting the legal heirs of the original respondent stroke defendant number 4 as unless and until the abatement is set aside, the legal heirs of respondent stroke defendant number 4 cannot be substituted as respondent numbers 4A, 4B, 4C, 4D, and 4E in the regular second appeal. Stop. That being so, it appears that the grounds sought for abatement is sufficient. Accordingly, the abatement and accordingly the abatement of our abatement in respect of respondent so and so 4 in the original suit stands set aside. Application stands allowed. Sufficient?
Yes.
Anything to be done more here?
No.
Now, substitution conduct.
There's one more abatement of R6.
R6, which is that?
That is 2999.
এইবোৰ সব চাই ল'ব disposed of the এই 2999 একেখিনি সব থাকিব খালি R6 হৈ যাব R4 ৰ জানা correct?
Yes.
Everything same?
Now 3000.
Disposed of. বুজি পাইছা নাই ভাৰ্গৱ? Now 3000.
3000.
This is the substitution.
Substitution.
The instant interlocutory application has been filed for substituting the legal heirs of respondent number 4, I. Shri Deviram Hajong, and respondent number 6, I. Shri Subol Hajong, in the regular second appeal number 260/2016. Correct?
Yes. My lordship.
It appears that the legal heirs, it appears that the original respondent number 4 and respondent number 6 expired during the pendency of the suit, right? During the pendency of the suit.
Yes.
Isn't it?
Yes, Your Honor.
During the pendency of the suit. Stop. However, since the applicant was unaware of the said demise of respondent number 4 and respondent number 6.
Pendency of the appeal in this case.
First appeal?
No, second appeal, because 6 years back, Your Honor.
Pendency of the 6. During the No. It appears that the respondent number 4 and respondent number 6 has expired during the pendency of this appeal, and accordingly, this application has been filed for substituting the legal heirs of the respondent number 4 and respondent number 6, respectively. Stop. Correct?
Yes.
I think now I have correctly said.
Yes.
It's very confusing.
Yes, Your Honor.
So many I's you have brought. Condonation, then abatement, now substitution.
And second appeal is also with regard to delay only.
Correct.
The original second appeal.
So, Ms. Borwam, my court master will inform you once the order is typed out before signing, just
Yes,
just you or your junior may just have a look at it.
Yes.
In case of any typo errors or factual error, please inform the code master and I shall do it because I think in some places something might go wrong.
But but Lordship dictation was very appropriate. I was reading, listening carefully.
No,
Yes.
it's all right. Nicola? It further appears that, no, sorry, it's Bhargav, just read it again. MS S. Borwal, Learned Counsel submits that unless the legal heirs are substituted, legal heirs of the respondent number 4 and 6 are substituted, serious prejudice would be caused to the applicant. Stop, heard, perused. It appears that during the pendency of the second appeal, the original appellant, Shri Suren Gogoi, expired on 3/8/2019, and the deceased appellant left behind his two wives, namely Momi Gogoi and Pompi Dr. Gogoi, and 4 sons and 1 daughter, namely Chandan Gogoi, Anne Gogoi, Suraj Gogoi, Dibbajut Gogoi, and Pradhan Gogoi. Itu একই নালাগে।
I think 5 and 6 will be relevant.
That's right, that's right. I just realized. These are the earlier.
Yes, that is pending already. That is given. 5 and 6.
Relevant paragraphs of the application is reproduced here under for ready reference are rated to be 2, 3, 4, 5, 6. Reading of the aforesaid paragraphs, it appears that the original respondent number 4 has expired during the pendency of the second appeal. And as such, his legal heirs are required to be substituted as respondent number 4A, 4B, 4C, 4D, and 4E, being the other surviving legal heirs who has not been as the other surviving legal heirs. Stop. It further appears that the original respondent defendant number 6 has also having expired. His 5 legal heirs with regard to respondent, his 5 legal heirs are required to be substituted as respondent number 6A, 6B, 6C, 6D, and 6C, being the other surviving legal heirs. Accordingly, where are their names?
Their names are in the page number 5 and page number 6 and 7 of the course right.
Accordingly, page 5. on the death of Sri Deviram Hajong, his legal heirs, actually এটা পাই যাবা ঠিক আছে is substituted in place of respondent number 4, and on the death of Subul Hajong, his legal heirs 6A pra লিখিবা 6E লেগে লিখিবা is substituted in place of respondent number 6. Substitution application accordingly stands allowed. Let a amended cost title be submitted before the registry for doing the needful. Allowed. Any more IAs?
No, that will be later on. They have objects. Obliged to.